It is my pleasure to welcome you here today to the Spring 2025 St. Thomas Law Journal Symposium, Navigating Polarization. It is our pleasure to be hosting the symposium today. Please feel free to grab some coffee or refreshments in the back. The restrooms are to your left, all the way to the back, if you need to use it. We are so excited for the event today, and we are looking forward to all our great panelists and speakers. It is now my pleasure to call up to the stage our law school dean, Dean Kelly.
Thank you, Julia, and welcome everyone to the University of St. Thomas School of Law. My name is Dan Kelly. I serve as Dean and Mengler Law here at St. Thomas. Welcome to what's going to be a fantastic symposium on navigating polarization, the role of the First Amendment. Just want to offer a few very brief remarks. First, thank you to everyone on the Law Journal, from Julia as editor-in-chief to all of the editors. Fantastic job. Let's give them a round of applause. So I love the theme that they chose this year on navigating polarization for a couple of reasons. One, it seems to be very timely, which is always good for a symposium topic, to have a timely topic. At the same time, I think it's a topic, navigating polarization, that's timeless. And when you're picking a symposium topic that's going to last for the ages, especially in the pages of the Law Journal, it's also good to have a timeless topic. So I think it's both timely and timeless, because when you think about polarization, yes, we tend to think about the moment and the controversies that are going out, but really most ages and most periods of US history and maybe even world history have a lot of polarization. So not just the 2020s, but if you think about the 2000s, starting with the election of 2000, the Iraq War, many other events. The 1980s, we had fierce debates. If you think about the 1960s, a turbulent time, and there were lots of issues with the First Amendment, free expression, freedom of speech. The 1930s, the battles about the New Deal. Going back to the Civil War, obviously extreme polarization where the country was at. And even going back to the founding with the debates between the Federalists and Anti-Federalists. So it's both timely and timeless. Two quick comments and why I think maybe the current moment we might have exacerbated the situation on polarization, or at least a couple of factors. So one, I think that gets mentioned a lot is the role of the media, and especially, I guess I would say, social media. So there's always kind of been the media and, going back to the old newspapers. But social media, I think in particular, brings out a lot of polarization. People can say pretty much whatever they want to say. There's a certain degree of anonymity, so I think that has contributed to it. Another factor I think that maybe goes less noticed is I think in our contemporary time, politics almost becomes everything. I feel like the United States used to historically, and maybe I'm just being naive here, but we used to have more space for other types of common ground and agreement, right? That politics didn't dominate everything. And that kind of goes back all the way to Tocqueville's thesis in Democracy in America about the importance of mediating institutions, right? Whether that's clubs, organizations, churches, other things that are not part of the individual or part of the government or state that bring us together in common ground. And just a few decades ago, Robert Putnam's book, Bowling Alone, also highlighted in a very social scientific way the fact that Americans generally are not doing some of the collaborative activities that they used to do. So now, instead of having things, whether it be clubs and meeting spaces, sports, a good example, religion, right? Now everything seems to be about politics, and I think that deepens some of our divides and polarization. So in terms of what to do about those things, and I know there's going to be a lot of discussion about this later today, but I would posit on the media and social media prong, we shouldn't retreat from the importance of free speech, both in terms of fundamental freedom of speech, First Amendment values vis-a-vis the government, but also the importance of free speech, even in the private sphere, including and maybe especially in universities and law schools. And then in the second one, the sort of creeping that everything boils down to politics, I think we need to focus on the fact that we need to create places and spaces where we have community activities that aren't just about politics. So those are just two possibilities. Fortunately, we're brought together today to use our free speech and also to join together the community. So this symposium itself might be a bit of an anecdote to these ideas or these troubles of polarization. So we have a number of great panels coming up, including ones on constitutional law doctrines and social and political conflicts, free speech and conflict, the Israeli-Palestinian conflict, and a panel on interdisciplinary perspectives, social science, and judicial rhetoric, as well as at lunch, there's even a demonstration on productive dialogue. So once again, welcome. Look forward to all of the great presentations, the discussions. Again, law school and universities are a place where freedom of speech should reign supreme, and I think this symposium will be a shining example of that. So without further ado, I want to call forward Professor Tom Berg, and Professor Berg is going to introduce our first panel. Thank you, and welcome once again.
Thank you, Dean. I want to acknowledge my co-organizer of this symposium, Professor Asma Udine, who is at Catholic University. She will be joining us by Zoom later this afternoon. She was not able to be here in person, but she and I have both written on polarization over the last few years. I have a book creatively titled Religious Liberty in a Polarized Age. She has two books on religious liberty, polarization, Muslim-Christian relations, and so on. And we have been talking over the years about the role of religious liberty as a potential source of amelioration of our current divides, and coming from our own different experiences and places on that. There is nobody in the country better situated as a scholar of law and religion, also a devout Muslim, practicing Muslim, Asma, with her background at various organizations as well. So it's been a real pleasure to work with her over the years and on this symposium. It is the product of her intellectual heft and practical thinking. We wanted a demonstration, which we will have from Reverend Jeff Thiemann of the Braver Angels organization, which many of you know is a nationwide organization dedicated to showing people, teaching people, giving them the opportunities to engage in dialogue across lines in productive ways. I'm going to say something only very short about the subject matter. The First Amendment is in some ways clearly a response to polarization. James Madison, the sort of father of the religion clauses and maybe of the Bill of Rights as a whole in general, in his famous memorial and remonstrance against religious assessments, argued for freedom of religion in America on many grounds. One of them, he said, was, "Torrents of blood have been spilt in the old world by the vain attempts of the secular arm to extinguish differences of opinion in religion." And every attempt to solve religious disagreement by government force has failed, but every time the cure, he said, has been the recognition and the granting of religious freedom. It doesn't eliminate the disagreement, but it eliminates its, now I'm forgetting the exact words, but its damaging effects upon the body politic. So with the religion clauses of the First Amendment, we have a grounding clearly in a time of intense polarization in which that fellow there behind us gave his life as a martyr in the Catholic Protestant wars in England, after Thomas More, let's be honest, had helped send Protestants to execution. So it was a back and forth, as we find so often in our polarized times now. Freedom of speech can also serve as a release valve for conflict, allowing the expression of disagreement rather than suppressing it. But there are also all sorts of complications. Speech in some ways obviously contributes to polarization. Speech can be not only sharp, but damaging. What doctrines are best suited for the First Amendment to play a kind of productive role in ameliorating polarization? And what other goals does it serve that are quite different? Is this even the main goal of the First Amendment? The last thing I want to say about the subject is that we're also going to be really fortunate to have some social science presentations as well in the afternoon on what we know empirically about speech, religion, and polarization. And lastly, I want to thank the editors, Julia, and particularly Mason Rademacher, the Symposium editor, for really tireless and wonderful work on this. So with thank you to Mason, let's clap for all of those who have worked so hard. I should mention Devin Donskoy, our event manager, also plays a huge role in these events as well. So thank you to Devin. With that, I'll turn it over to Mike Paulson for the introduction of the first panel.
Good morning. Welcome to the first panel. My name is Mike Paulson, and some of you know me. I'm a law professor here, and it's my great honor and privilege to moderate this panel, which is a fantastic panel. You have bios in your program, so I'll be as brief and rapid as possible so that they have more time to talk. Zach Price is the Eucalyptus Foundation Endowed Chair at the University of California College of Law, formerly known as Hastings. He teaches constitutional law, and a man after my own heart, he teaches civil procedure. He's a graduate of Stanford University, Harvard Law School. He clerked for Judge David Tatel on the U.S. Court of Appeals for the D.C. Circuit, and Justice Anthony Kennedy for the Supreme Court. He's also been an attorney at Office of Legal Counsel. He and I were probably about 20-some years apart in that office. And he also served for a fellow for a year at the Stanford Constitutional Law Center. Sitting right next to me is Daniel Chen, who's counsel for the Beckett Fund for Religious Freedom, Religious Liberty, which I regard as one of the leading religious liberty litigation public interest firms in the nation. Daniel and I met at Stanford a couple of years ago where we had coffee. He is a Californian. He's Cal Berkeley all the way, undergrad and law school, and he clerked in the Eighth Circuit for Judge Ray Grunder. Joy Mosley is the Vice President for Government and Strategic Relations at the Council for Christian Colleges and Universities. She's a graduate of Covenant College and has her JD from Emory University. And last but by no means least is Professor Brandon Paradise, who's the professor of law and the Dallas Willard Scholar at Rutgers Law School. He is a leading scholar on the intersection of issues of race and law and Christianity. He's a graduate of Yale Law School, Union Theological Seminary, and University of Southern California, which I believe is where Dallas Willard was a a philosophy professor. With no further ado, I'm going to strictly hold each speaker to 15 minutes, so then we can have some back and forth questions of each other, challenges. I promise, Tom, I won't induce torrents of blood, but just good conversation, and then we'll take questions from the floor. So we'll go in this order. We'll go Zachary Price, Brandon Paradise, Joy Mosley, and then Daniel Chen. Do I have that right? Is that what you're expecting, or have I crossed you up? We'll start with Zach Price.
All right. Well, first of all, thanks very much, Professor Paulson. And also, I want to echo the thanks to Julia and Mason, as well as Professors Berg and Udine and all the other organizers. It's a real privilege to be a part of this wonderful event. So I'm going to talk a little bit about a book I published last fall, and then discuss in particular some of the points it makes about the First Amendment, using a couple current Supreme Court cases as examples. And so basically, in keeping with the theme of the conference, I'll suggest that the First Amendment is indeed a key tool for navigating polarization, but only if it's understood in certain ways. Okay, so that's the plan. The book is called Constitutional Symmetry, Judging a Divided Republic, and it makes a general argument about constitutional interpretation. The basic thesis is that in our polarized and acrimonious moment, courts should favor, when possible, constitutional understandings that operate what I call symmetrically. And by that I mean that operate in a way that protects interests on opposite sides of key societal divides instead of on just one side. So that's a bit abstract, but my paradigm example is actually the First Amendment, the expressive freedom doctrine. So as you probably know, modern free speech jurisprudence is organized around requiring either content or viewpoint neutrality in speech regulation. And that approach has the virtue of symmetry. It protects all speakers no matter where they fall on the spectrum, no matter what they're saying. So the effect of that is to implement this key constitutional protection for expressive freedom in a way that, in principle, gives everyone a stake in the principle at issue and enables people disappointed with the result in one case to see how the same principle would benefit them or speakers they care about in future cases. So that's a good positive example of this symmetry I'm advocating. A good negative example is the court's Second Amendment jurisprudence. Understanding the Constitution to protect an individual right to bear arms basically constitutionalizes one side of a fraught political and social divide. And so it's asymmetric in my terms. Now, it doesn't necessarily mean it's wrong. I'll say more about that in a minute, but it does mean it's costly under current conditions. It alienates roughly half the country from a document that should be a source of shared commitments. So the basic idea I'm advocating is the courts, when possible, should favor doctrinal understandings that look like that First Amendment jurisprudence rather than those Second Amendment cases. So that's the proposal, and I should say it's not a full-blown theory of interpretation. I'm not suggesting that symmetry is always possible or always what courts should do, but I think that's actually a virtue, not a drawback. Judges these days have so basically I'm advocating as a preference, right, not a hard and fast rule, but I think that's a virtue because judges these days have, as you also probably know, quite varied primary interpretive commitments. And that means in terms of applying symmetry, they'll each have to decide when their primary commitments will and won't allow this sort of symmetric interpretation. But by the same token, a preference for symmetry could be something that judges with different outlooks could equally incorporate into their approach and possibly a point of convergence. So in that sense, it's analogous to something like judicial restraint, right? A judge who believes in judicial restraint would invalidate democratic enactments only when they clearly violate the Constitution. Figuring out when the Constitution is clear requires some primary interpretive theory, which restraint alone can't provide. But by the same token, judges with different primary commitments could sometimes converge on restraint. So symmetry is the same. It's something that judges can apply their primary interpretive commitments, figure out when it's possible, but again, could be a point of convergence for judges with different interpretive outlooks, and I think that's actually what's basically happened in the First Amendment area. So it's what you might call a second-order value in interpretation, like restraint, but I think it's actually the most important such value in our moment. So let me say a word about that, and then I'll circle back to the First Amendment. So, why advocate this value right now? So you all organized a conference about, navigating polarization, so it's probably obvious. But the problem for which symmetry is a solution is, of course, the way in which our current polarized politics are encouraging a politicization of constitutional law. Over the past 50 years or so, the two major parties have polarized, meaning they've become more distinct, more ideological, and as a result, the political system has become more divided and rivalrous, much more conflictual in how it operates. I think that level of animosity puts a lot of strain on the constitutional system. It leads people within the political branches to pursue short-term policy wins at the expense of long-term values. It also creates incentives for repressive behavior that threatens civil liberties. And in some ways, the point of the Constitution is to put brakes on that sort of behavior, to provide rugged rules of the road for the political system and guarantee basic civil liberties. But the problem is that the same trends have also fostered rival partisan visions of the Constitution, sort of efforts to achieve through constitutional law some of those same political goals animating the political process. So I think it's a bad combination. The political environment is making durable constitutional rules particularly important at the same time that it is encouraging opportunistic approaches to interpretation. And it seems to me the end result is a lot of public cynicism that certainly threatens judicial legitimacy, but could actually imperil the whole notion of shared constitutional commitments. So I think this is really the central challenge for contemporary constitutional interpretation. And it's a hard problem that we'll be discussing all day today. But I think the good news is that judges are aware of the problem and are looking for ways to manage it. Good judges don't want to be perceived as result-driven partisans. They want to be understood as neutral expositors of the law. But I think they need a way out of this trap, and they need a way that's going to work in an environment where there's a lot of disagreement, not only about interpretive theory, or not only about politics, but also about interpretive theory. So favoring symmetric understandings aims to do precisely that. So that's the basic argument. The book also makes a theoretical case for this principle on various grounds, including originalism, suggests it's already a kind of inchoate feature of constitutional practice. So I'm happy to talk about all that, but I think in light of our theme, I'll just turn to a couple First Amendment implications to hopefully make it a bit more concrete as well. So I'll make one general point and then talk about two more specific things very briefly. So the general point is that symmetry should encourage courts to sustain this focus on neutrality in the expressive freedom jurisprudence. So as I said at the outset, First Amendment doctrine is kind of my paradigm case, where the doctrine is highly symmetric. But it turns out that understanding is potentially questionable as a matter of first principles. It doesn't accord terribly well with founding era practice, at least arguably. It's really, interestingly, mainly a product of the civil rights era and the divisions and polarizations of that period. It's nevertheless a pretty strong point of consensus on the current Supreme Court, and I think its symmetry helps explain why that's so, but I think symmetry also provides a strong reason to sustain that orientation despite questions one might have as a matter of first principles. Okay, so that's one important general point. A second, more specific point, and one that might be more controversial on the panel, is that I think symmetry also provides a reason in some cases to favor expressive freedom rationales over religion-specific ones, even though the other clauses of the First Amendment specifically protect religion. So why would that be? As you're probably aware, one major trend in the Supreme Court decisions from the past decade or so for the Roberts Court has been to strengthen protections for religious liberty. I think the court thinks it's being counter-majoritarian and minority protective in doing this, thinks that religion is a major societal fault line and that contemporary secular progressives and the institutions they control are often quite hostile to traditional religion. I think that's quite right, and Professor Berg, among others, has written very powerfully about this general issue. But I think the trouble is that the same political animosities that lead to discrimination against traditional religion in some settings also make religion-specific court decisions politically polarizing. So, of course, the political division over religion is not total. There are plenty of progressive religious dominations and individuals, but I think it is true that religious liberty was once a broadly shared commitment at times when church attendance rates were more uniform, religiously observant Americans rates of religious affiliation were more general. But now, in the aggregate, religiously observant Americans are heavily concentrated on the conservative side of political divides. And this shows up in the jurisprudence. Particularly in recent years, judges appointed by presidents from the two parties have pretty different approaches to religious liberty cases. A striking example, for instance, is that in pandemic-related religious liberty cases, judges appointed by Democratic presidents ruled for the government every single time, whereas judges appointed by Republican presidents did so only 34% of the time, and Trump-appointed judges did so only 18% of the time. So you see this divide in our politics and then getting channeled in the jurisprudence. And I think in this context, resolving cases when possible based on expressive freedom or freedom of expressive association could produce a less divisive way of protecting religious believers precisely because it can equally benefit secular groups. So the Supreme Court does have a case where this issue is sort of working in the background this term, the Drummond case about whether states can exclude specifically religious schools from charter school programs. It's a tricky case. I think the school should probably lose, but if the court is going to hold that schools like this have to be included in charter programs, I think it should think carefully about extending that beyond just religiously specific schools to other secular schools with strong philosophical commitments. Okay, so that's a second, more specific example. Just very briefly, it's not quite a First Amendment issue, but another issue that's coming up a lot and implicates religious liberty and freedom of conscience is the question of parental rights. And this is another area where I think symmetry could be very helpful. So, this comes up in a lot of areas, but has come up most acutely with respect to treatment of gender dysphoric children, and the court has a case about that issue as well. But I think that symmetry matters here because it's quite literally the case right now that certain parental choices that are required, and more or less required or encouraged in some states, are considered abusive in others. And I think parental rights could be very important in this context, and could, as long as the court approaches them symmetrically so that they equally protect conservative parents in progressive states like California, where I live, and progressive parents in conservative states like Texas or Tennessee. So I'm happy to elaborate on all that, but that's the argument in a nutshell. I'm suggesting judges should favor symmetric understandings when they can, meaning understandings that benefit both sides of key partisan ideological divisions, but it's a preference, not a rule. And I think it can usefully inform adjudication with respect to the First Amendment as well as many other areas. So thanks again for having me, and looking forward to the discussion.
Professor Paradise?
So I'll say, as we're beginning, that this talk is going to touch on some of Dallas Willard's thought, which is only coincidental. I've only given 2 talks that touch on Dallas Willard, but I do happen to have a title with his name in it. In essence, the nature of my talk is going to be about how current conflicts over executive orders and state legislation impacting higher education around issues of race, gender, in higher education are really downstream from a broader crisis of reason that has taken hold in the culture for many decades now. So that's going to be the basic theme of the talk, and we'll see how good I am at really fitting this within 15 minutes. Hard to say much of anything in 15 minutes. Okay, so I've already captured, right, that we have a raft of federal and state laws, not even close to enough time to cover all of those. The big picture point is that there are many suits now pending in court, some successful, seeking injunctions because of the chilling effect and the vagueness that laws targeting so-called divisive concepts like race and gender, oriented themes in the classroom and DEI programming and university life have on the ability of professors and staff to explore these concepts without limitations on their academic freedom and free speech rights. Okay. Now, Dallas Willard argued decades ago that university life had moved away from reason as the driving, overriding force animating academic research. And his view was that reason is really a living social practice. It's designed, it's a faculty that allows us to apprehend the truth. The problem was so much academic research over many decades became preoccupied with ensuring that the right conclusions were reached. And unfortunately, I don't have time to go through this with a great deal of care, but there's a long history going back through the philosophical literature. If you're familiar with people like Alasdair MacIntyre, you're familiar with the basic landscape there, but it traces all the way back to the early part of the 20th century, the rise of logical positivism, the rise of emotivism, and the idea that especially when we're talking about claims regarding the moral life, we're really making statements that don't refer to any objective moral facts. Now, truth, as Willard understood it, I also believe this is the right way to understand it, is consistent with the correspondence theory. And that just means that truth, a claim is true when it accurately represents what the claim is about. That's when it's true. Now, if reason is the capacity to understand truth, then diversity can expand our comprehension of the truths that are out there. And this is partly reflected in some of the CRT literature when we talk about the experiential forms of knowledge that are widely associated with that movement. The basic idea would be, if you're looking at it from, say, a phenomenological point of view, is that there are regions of being that may be only accessible through a particular location in society. Now, the exclusion then of historically marginalized voices can then limit our access to certain forms of truth, even while I would hold, although I can't really expand on it here, that the reports about particular experiences based upon racialized or gendered identities should nonetheless be subject to rigorous interrogation and criticism and rebuttal by people who don't share those experiences. Now, this is all to say that inclusive academic environments are designed in principle, ideally, although I would say not often and not always the case, to make meaningful contributions to academic life possible by everyone regardless of their background. Now, we're going to get to the law part pretty soon, but here's a basic distinction I think that really is at issue in much of what we're seeing with the executive orders and federal federal efforts to penalize universities who are involved in DEI programming in states like Florida, who are attempting to root out discussions of race and gender that they disagree with in the classroom. So a reasonable person governs his or her beliefs and assertions by insight into truth and logical relations. Now, this is just to say that the reasonable person is not driven by motivated reason. They're not focused on securing the conclusions they would like. They're instead committed to arriving at conclusions based upon a careful review of the evidence. And logical relations just means things like contradiction, implication, right? Those are basic form, non sequitur recognition of where there is a non sequitur. Those are basic forms of logical relations that people should be committed to following if they're reasonable. Now, the unreasonable person, in contrast, is driven by a desire to reach preferred conclusions. Now, this is wrapped up and tied to the effort to root out DEI and to root out divisive concepts that are found in some of the critical race theory literature. For example, critical race theory is widely known to claim that racism is a permanent feature of American society, and the Texas legislation certainly targets that kind of notion. The problem there is by targeting that notion and not evaluating it on the basis of reason, then we move away from evaluating the claim based upon the evidence. Okay. Oh, last point, I didn't get that last one. I wanted to mention that reason is a moral practice, and this is something I can't get into in a lot of detail here, but it essentially requires a person committed to advancing the goods of human life and committed to a certain form of ethical reasoning, rather than someone who is instead committed to advancing their own agenda. Now, what's the problem of government intervention? As you probably know from Trump's orders and the recent Dear Colleague letter that was put out on February 14th of this year, the government is attempting to claim, the federal government attempting to claim that efforts to crack down on DEI in campus life is really an effort to address legal discrimination. The problem with that, though, is it ends up imposing an orthodoxy of its own, because it essentially substitutes for DEI and gender theory and critical race theory on campuses another alternative ideal, and namely that ideal would be a categorical regime of colorblindness that the Trump administration would like to see developed on the basis of students for fair admission, the students for fair admissions case versus Harvard. Okay. Move on from this. Now, for decades, as you know, critics have argued that higher education is captured by the political left. And so there's this long-running theme, especially in conservative circles, that the humanities especially are dominated by the political left. And so the efforts that we're seeing now to sort of reverse the influence of critical race theory and gender theory and DEI on campuses is more or less the fulfillment of hopes to clear out of higher education the dominance that the left wing has enjoyed, according to some accounts, for many decades. Now, Trump passes and adopts an executive order in 2020 that Biden rescinded. That executive order targeted 9 divisive concepts. 2 of them I give you here. One is that one race or sex is inherently superior. Now that refers to concepts that you've probably heard of, like white privilege, for example. So it would sort of fall under there. The U.S. is fundamentally racist or sexist. That would go to the idea in critical race theory that U.S. society is permanently racist. Biden rescinded that order, but that order did serve as a model for state legislation across the nation. Most, I think, well known would be the Texas Stop Woke Act. I've already mentioned the court wants to leverage the recent affirmative action decision to justify defunding DEI through extending the holding, eliminating race-conscious admissions to the use of race across campus life in general. Now, really quickly, I'll talk about the Stop Woke Act. So if you look at that second bullet point, okay, the Stop Woke Act prohibits within the classroom espousing, promoting, or advancing discrimination for diversity, equity, or inclusion. In effect, this means you can't argue in the classroom on behalf of the merits of affirmative action. You can't do that because you're not supposed to use race defined in the Florida Stop Woke Act to advance equity or inclusion, which means you would be forbidden from teaching that within the classroom. If you do so, you could lose funding. The second bullet point under that sub-bullet point, the idea that merit, fairness, objectivity, and racial colorblindness are inherently racist, really attacks critical race theory's view that merit and colorblindness and objectivity are artifacts of relations of power that attempt to continue and perpetuate racial subordination. Now, federal restrictions on DEI in higher education have come out with such a speed and such a fury that it's hard to keep track of them all. There are many cases pending. I'm only capturing a few of them here. I'm not talking here about the recent order on anti-Semitism because we have a panel later today that I expect will address some of that as it relates to university campuses. I think the key thing is just to focus on the fact that the first executive order from January 20th requires federal grantees, meaning universities who receive tons of money, right, from the federal government, to terminate all DEI programming. What programming they consider illegal DEI. The difficulty here is the order does not define what constitutes illegal DEI. That creates all sorts of challenges around the First Amendment. We have no idea what that means. It creates a problem of vagueness, and it chills free speech. The second order, January 21st, requires federal grantees to certify that they don't promote DEI programs that violate federal law. The problem there is we don't know which ones are said to violate federal law. We're kind of in the dark there. The third bullet point there I've already talked about. It's the Dear Colleague letter written on February 14th that essentially seeks to leverage the affirmative action decision to end the use of race across all higher education institutions that receive federal financial aid. So polarization over the First Amendment and equal protection doctrine. So the polarization here in the First Amendment is really quite, interesting because the basic claim when you listen to people who are defending the executive orders and the state legislation that's arisen across the nation is that restrictions on what can be taught in the classroom and restrictions on DEI and campus life are necessary because the teaching of certain kinds of concepts within the classroom and certain forms of DEI activity, which they don't define what they mean there, are themselves authoritarian and dogmatic, and that they therefore depart from the academic enterprise of free inquiry. Now, the response there is to claim that DEI programming, gender theory, race theory is consistent with reason, not authoritarian, and intends instead to expand the breadth of academic activity on the campus and to ensure an inclusive learning environment. Now, equal protection doctrine has long been the subject of polarization. It's been the subject of polarization since nearly the Equal Protection Clause was adopted. It's been a source of polarization for a very long time. But in the contemporary period, the main polarization has been around the colorblind interpretation of the Equal Protection Clause versus the race-conscious interpretation of the Equal Protection Clause. The Trump administration is attempting to use, as I've said, the Harvard case to justify categorical colorblindness across all aspects of the federal government, not just higher education, although that's what I'm focused on here. Now, the crisis at hand. So political interventions in higher education, particularly around race, gender, and DEI, challenge academic freedom and undermine reasoned inquiry insofar as they make a judgment without permitting academics to engage in reasoned evaluation of the particular forms of DEI programming, for example, that are occurring. By making that judgment and categorically excluding DEI programming as certain kinds of race and gender discussions in the classroom, we're seeing the imposition of a particular form of ideology by the federal government. Now, when Willard says that reason had been abandoned in university life, what he really meant there was that knowledge defined as the ability to represent something as it is on an appropriate basis of thought and experience should define what it is to be an institution of higher education and what it is to be an academic. The challenge has been for many years now, and not just now, that we don't really know what it is, what knowledge is. So if you ask someone, for example, why is systematic racism true or not true, they'll give you arguments about that on both sides of the equation. But what we're seeing today is institutions themselves, consistent with Willard's diagnosis many years ago, moving away from issuing any kind of statements about anything. So moving into the position of neutrality. I think this is exactly an underscoring of the extent to which universities themselves don't really purport to have actual knowledge about what counts as systematic racism or what counts as a social injustice around a whole host of issues. Individual academics will hold views on particular issues, but are we really prepared to say that we have actual knowledge about many of the claims around social justice that we are making? Now, we should resist ideological impositions by the government into academic life because that's inconsistent with open critical discourse, the application of reason, and the search for truth. And this would mean instead of doubling down on, and unfortunately I don't have a lot of time left, but instead of doubling down on some of the more, I would argue, dogmatic aspects of critical race theory and gender theory, we should instead rededicate American institutions to a careful, attentive academic enterprise where reasoned conclusions involving debate among people from a wide variety of perspectives is the norm. I can tell you from just the 15 years I've been in the academy that it is fairly hard to find people in the academy who are evangelical Christians, fairly hard if you're in a secular university like mine, fairly hard to find conservatives. I don't count myself to be a conservative. I'd like to have more conservative colleagues. It's fairly hard to find that. And I think that does reflect the drift away from careful reasoned analysis into an ideological mode where the university is not open to arguments from all sides. Now, that creates a challenge in an environment where the opponents of the left are themselves in the seat of power, and they're now working very carefully and I think very vigorously to attempt to end the reign of the left political dominance of higher education. Now, I think I'm just about out of time now, so I'd like to turn it over to the next speaker. Was it Joy?
That's great. Thank you. and he made it within 15 minutes easily. Our next speaker is Joy Mosley. Joy?
Hi, everyone. Thank you for having me. So as I thought of the discussion topic about ways to depolarize religious liberty, I want to suggest a vital link between Christian principles and classically liberal ideas regarding government. And as we minimize or eviscerate Christian principles, I'm going to argue that it's actually significantly impacting our civic life. And so one way to address that is for Christians to be more Christian. So that's kind of going to be the roadmap for how we think about things today. And I'll start with two quotes from our founding fathers. The first from George Washington from his farewell address, where he says, "Of all the dispositions and habits which lead to political prosperity, religion and morality are indispensable supports." And then from John Adams, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other." The Constitution protects religious liberty not for partisan reasons, nor as a thumb on the scale between religion and irreligion, but because religious belief and exercise are fundamental, part of a human being's inherent natural rights, a source of meaning, community, identity, guidance, and it is deeper than civil society and transcends it. And the First Amendment can be polarizing, as we've discussed on this panel already. And the First Amendment is not blind to the polarizing effects of religion. The founders were well aware of these effects, as Professor Berg mentioned in his introductory remarks. But their unique solution was not to establish one religion above all others, nor to institute a militant secularism in which religious belief and practice were extinguished or eviscerated. Their solution was religious pluralism, disestablishment, and free exercise, prohibiting government coercion in matters of faith, but then at the same time unleashing the religious energies of the people, allowing them to believe and practice freely, contribute to the common good, and even compete for competition and recognition and adherence. The idea was that while religious differences tend to inflame, religious freedom tends to diffuse. And Americans were already religiously diverse in the 18th century, and they're even more so today. And we never did, and we won't now agree on theological matters. And the framers of the Constitution never intended us to agree. The First Amendment is designed so that those enduring sources of division should be irrelevant to civic matters like public policy, elective office, legislation, which lowers the stakes of politics and allows political efforts to be judged on their civic and public merits rather than on their religious particulars. This tradition of religious pluralism and religious freedom means that the United States is not a Christian nation as such. Its institutions are grounded in a set of secular, classically liberal ideas about human equality, popular sovereignty, limited government, the rule of law. These ideas depend on a substrate of moral values that Christianity supplies, but in their everyday outworking and everyday application, they don't hearken back to Christian theological principles, which is why disestablishment and free exercise work. So it's as though the subterranean, and thus the usually invisible below ground bedrock is Christian, while the visible above ground civic foundation is secular and liberal. And the essential relationship between these two is not always well understood. And if that above ground civic foundation cracks, it's repairable, and America has had to attend to that kind of repair work over the years. But what if that bedrock begins to crack? Then what? That repair work is deeper than civics, deeper than the Constitution, and I would argue that repair work is theological. And I think there's a sense in which the bedrock is becoming unstable. I mean, I don't need to tell folks in this room about trends like the great dechurching and the rise of the nuns, and we've seen mainstream denominations decline, thin out, and secularize. We see broader cultural trends like consumerism, hyper-individualism, loneliness epidemic, a crisis of meaning, deaths of decay, things like that. And so this de-churching of politics and society has not ushered in an age of reason or even a neutral but liberal secularism, if such neutrality could even exist. It seems rather to have unleashed the worst vices of human impulses on both sides of the political spectrum. And politics as an arena of combat without the moderating force of religion is vicious, inflamed, and even dangerous. This growing illiberalism of the American public square has led many committed secularists, even atheists, to wonder whether religion in general, and Christianity in particular, actually is essential, if it is that below-ground bedrock. So Tom Holland, in his book Dominion, talks about ideas that secular liberals hold dear, like human dignity, equality, care for the poor, the vulnerable, and the victim. But these are not self-evident truths, but ideas that Christianity uniquely gave the West. Richard Dawkins is an atheist, but even he started to call himself a cultural Christian. And another example, we're going to spend some time on Jonathan Rauch. And in his new book, Cross Purposes, Christianity's Broken Bargain with Democracy, he argues that religious faith and secular liberalism need each other. Not just that one is instrumentally related to the other, but that actually each is intrinsically reliant on the other to provide a complete and a coherent account of the world and to supply the moral goods needed for a healthy republic. So Rauch uses this economic metaphor where he articulates a cultural trade deficit. He says that secular liberalism promotes important values, tolerance, rule of law, civic virtue, but the legitimacy of these values depend on something outside of itself. Their legitimacy rests on a religious and, in America, a Christian bedrock. He says secular liberalism, quote, relies on Christianity to maintain a positive cultural balance of trade. We need it to export more moral values and spiritual authority to the surrounding culture than it imports. If instead the church is in cultural deficit, if it becomes a net importer of values from the secular world, then it becomes morally derivative instead of morally formative, end quote. So religion's becoming a consumer good, indistinguishable from larger society, which then makes it incapable of performing its role as a former of moral virtue and a checker of vice and impulse. And Rauch thinks this is where we are now, so hence his subtitle that Christianity has broken its implicit bargain with liberal democracy. It's secularizing, aligning with political forces both on the left and the right in a will to pursue power, rather than following a countercultural ethic that emphasizes Christian values and principles. And then the result is that liberal democracy will not, and indeed cannot, hold up its end of the bargain either. Without the moral bedrock that religious faith provides, the foundational liberal values will also start to crumble. Basically, an unreligious America is an illiberal America. Okay, so then what should Christians do? Well, my contention is that Christians should be more Christian. So let me share a story. I started at the Council for Christian Colleges and Universities in the fall of 2019, right from law school. And one of my very early meetings was with someone who was interested in protecting Christian higher education and wanted to talk through some ways to do that. So we talked through things like religious exemptions, faith statements, annual affirmations of those faith statements. And at the end, he asked an open-ended question about advice that I would give Christian colleges in this context. And I said that Christian colleges need to be more clearly religious, more upfront about their beliefs and expectations, both of students and employees. I mean, it helps no one if they feel subject to a bait and switch. To claim a religious exemption, institutions need to be clearly and authentically religious. And he was very surprised and said he thought that I would have said the opposite, that colleges need to just put their heads down, that they need to tone down some of their expectations, maybe soften some of those countercultural behavioral requirements. Now remember, I'm new in this role, fresh from law school. This man has a lot of experience, and I think, oh no, did I give the wrong answer? But 5 years later, I'm still convinced I was right. And I'm not the only one. So going back to Rauch's argument, he comes to the same conclusion. The surprising answer from his book is not that Christians need to be more liberal or more secular, but they should be more Christian. Now, for me to make this argument, it makes sense. I'm a conservative Christian from a theologically conservative denomination, from the Bible Belt, works for an evangelical organization. But for Rauch to make this argument is pretty remarkable. Rauch is a gay Jewish atheist, and his book represents a 180 in his thinking, away from an apathetic secularism and toward religious faith, and Christianity in particular, as essential to the American experiment in ordered liberty. Secular liberalism needs Christian institutions to continue their historic function of moral formation, even countercultural moral formation, and to continue exporting those moral goods to the surrounding political culture. But Christian institutions that secularize, whether that's on the illiberal woke left or the illiberal MAGA right cannot fulfill this role. And neither can a thin Christianity that sees faith only through the lens of politics. To be more Christian means living faithfully in accordance with the Bible, to attend to the daily work of taking up your cross and following Jesus, to deny the old nature and put on the fruit of the Spirit. And so instead of becoming secularizing or becoming militant, Christian institutions must stand firm in their biblical mission. And I'm going to talk about Christian colleges and why I think they have a unique role to play in this, but I know that there's a range of religious colleges, from ones with a historic founding to ones with a more loose affiliation. And I'm going to be talking about colleges that are explicitly and thoroughly Christian. So as an example, to be a full governing member of the Council for Christian Colleges, we require that institutions require a statement of faith from their faculty and full-time administrators. So we think that's a really good metric to determine if the school is only historically Christian or if they're intentionally integrating the authoritative Word of God into every aspect of campus life. And my role in the organization originally focused on the external advocacy challenges facing Christian higher education. But the longer I've been in this role, I would actually argue that the most pressing threat to Christian higher education is not external, but it's internal in terms of mission drift. And when institutions give in to cultural pressure to conform to the world, they chip away at that bedrock, which then makes the civic foundation unstable. And I contend that part of the reason for this trade deficit is that churches disciple congregants pretty well in their personal walk with Christ, in their personal holiness, but maybe not quite as well in their public lives, their communal lives, their online lives, not in how that personal relationship with Christ is on display in your workplace, in your politics, in your social media post. And I think Christian institutions, and I would suggest Christian colleges in particular, have a distinctive role to play here to address that trade deficit, because Christian colleges, one of the key distinctives is both the private and the public shaping of the heart, mind, and soul. Faith is not just relegated to a few hours on Sunday. It's integrated into the chemistry classroom, into the sociology classroom, into the economics classroom, into the ball fields, into the student clubs, and into the late night conversations with roommates. But Christian institutions cannot do this private and public moral formation work without the freedom to determine both what those moral values are and how they will be inculcated in students in the next generation. Expecting that Christians be more Christian without then giving them the freedom to be more Christian is a contradiction in terms. And I think this is worth pausing to emphasize. Christian institutions must have the ability to have the right to hire only those who will agree with and live out its mission, to determine the contours of your community, including enrollment, to live out particular doctrines consistent with your faith, even if they're countercultural. Living out particular doctrines consistent with your faith reminds me of a story from my alma mater. So I graduated from Covenant College, which is part of the Presbyterian Church in America. And a few years ago, our tennis team was doing really well. For some context, we're an NCAA Division III school, so generally we're better academics than sports. But this year was a good year for tennis. I think our conference record was like 11-1 or something. And our tennis team made it all the way to the championship. And so everyone was excited. Of course, the team was excited, but our whole student body was excited. Even our local community was excited, again, because this was a bit rare. But the conference planned to hold the championship match on a Sunday. And even though Covenant had always filled out the NCAA religious accommodation form, the conference chose not to honor that accommodation. They refused to change the day of the match, even though the other teams agreed to the change. So Covenant faced a tough choice. These athletes had worked hard and had gotten really far. But Covenant and the PCA hold the Sabbath in high regard and decided that keeping the Sabbath holy meant forfeiting the game. And I wish that the conference had been more pluralistic and allowed the championship on a different day. But if you're going to stand firm in your biblical mission, I would hope for a more pluralistic approach. But I also say this to say you have to then stand firm in your convictions, even if an accommodation is not going to be granted. Okay, so to bring it back, we'll go back to that economic metaphor of exchange. So in exchange for this freedom to hire, and I think it also has to be mentioned that that includes freedom to fire, to teach truth, to create an explicitly Christian community, then colleges need to ensure that faith integration extends beyond the classroom to every aspect of campus life, to ensure that biblically minded faculty and staff are pouring into students, living out what it means to make every thought captive and make it obedient to Christ. And as these graduates serve in all walks of life, they should carry with them the duty and the privilege to act justly, love mercy, and walk humbly with their God. And if these institutions become more Christian, if students become more Christian, if church members become more Christian, then my prayer is that, as Isaiah says, justice will dwell in the wilderness and righteousness will abide in the fruitful field. So as we do this vital work of repairing the Christian bedrock, we can start to reverse the cultural trade deficit and export moral goods to the surrounding culture, strengthening both the bedrock and that above ground secular liberal civic foundation.
Thank you. Daniel.
Can you hear me? Great. Thank you all very much for having me here today. Our symposium addresses polarization in the First Amendment, and I want to talk about that question from the perspective of the religion clauses and religious liberty. Now, to many people today, in fact, perhaps to many of you listening, religious liberty can seem like an anachronism, especially when talking about polarization. Perhaps that's because to you, religion and religious liberty seem like the cause of polarization instead of the cure. But I humbly submit that religious liberty, rightly understood and rightly practiced, is a remedy for polarization. In the words of Professor Berg, religious liberty, quote, reduces the hostility, alienation, and fear that arise from deep disagreements within a society. Now, to understand where we are today, I think it's actually helpful to go back in time and understand the historical antecedents for religious liberty. And in America, that means the European wars of religion and colonial history. And the lessons from that history, I posit, endure, and they provide a primer on what a well-functioning religious liberty regime should look like. Now, my historical recap is going to be general and truncated. The European wars of religion, they included many countries, but I'm going to focus on the English experience because that history was the most relevant and front of mind to the founders. So bear with me. The Reformation began in 1517 with Martin Luther and his 95 Theses. The English Reformation began a few decades later with Henry VIII. Actually, Henry VIII was originally a really ardent Catholic. He earned the title Defender of the Faith from the Pope because he attacked Martin Luther. But when the Pope refused to annul his marriage to Catherine of Aragon, Henry assumed authority over the English Church. Anglicanism under Henry VIII was actually basically Roman Catholicism, but without papal supremacy. But Henry persecuted anyone who challenged him or the validity of his second marriage to Anne Boleyn. Henry had swiftly established state supremacy over religion, but religious battles were just beginning. That's because if the state controls religion, then religions must fight for control of the state. Following Henry's death, the English state seesawed back and forth between different religious groups. Edward VI, his son, was a true Protestant believer, and with Thomas Cranmer, he standardized religious worship in England through the Book of Common Prayer and enforced religious uniformity through law and persecution. Then Mary I, Edward's half-sister and a Catholic, ascended the throne. Mary sought to reimpose Catholicism on England. She persecuted Protestants, forbidding Protestant liturgy and conducting heresy trials. It's estimated that approximately 300 Protestants were burned at the stake during Mary's reign, including Thomas Cranmer, hence the name Bloody Mary. Next, Queen Elizabeth the Protestant succeeded Mary. She reinstituted the Book of Common Prayer and the Act of Uniformity. The Elizabethan settlement, as it was called, it was a broad form of Protestantism, meant to be a middle way between the purported excesses of Catholicism and Calvinism. But it was also incredibly repressive. Puritans and other dissenters were forbidden from worshiping according to their religious beliefs, and hundreds of Catholics, including Elizabeth's own cousin, were killed during her reign. And the Elizabethan settlement proved no better at quelling religious discord, which continued, only this time within Protestantism. The English Civil War, which included religious disputes between Puritan Calvinists and High Church Anglicans, and probably Scots Presbyterians and others, killed hundreds of thousands of people. It led to the execution of an English monarch, the protectorate under Oliver Cromwell, and the restoration of the monarchy. And that in turn led to the ascension of James II, another Catholic monarch who sought to reinstitute Catholic liturgy and theology into the English Church. He was eventually deposed in the Glorious Revolution by William and Mary. This pattern unfortunately continued in the American colonies. Puritans fled to New England to worship freely, but then denied those same exact rights to others. They expelled people like Roger Williams and Anne Hutchinson, and even hanged Quaker evangelists on Boston Common. What can we learn from this history? What did the founders take away? Like Professor Berg, I take a lot away from James Madison, who was the chief author of the First Amendment, and from his Memorial and Remonstrance against Religious Assessments. If you haven't read that document, I went back and read it in full, and it's just an amazing document if you think about religious liberty, about human dignity, about theological beliefs, about religious liberty, about rule of law, defenses of religious liberty. But I want to focus on the reason why we're here today, which is about reducing civil strife and mitigating polarization. This is what James Madison had to say. This is the torrents of blood. Torrents of blood have been spilt in the old world by vain attempts of the secular arm to extinguish religious discord by prescribing all difference in religious opinions. Time has at length revealed the true remedy. Every relaxation of narrow and rigorous policy, wherever it has been tried, has been found to assuage the disease. America has exhibited proofs that equal and complete liberty, if it does not wholly eradicate it, it sufficiently destroys its malignant influence and health on the prosperity of the state. What's Madison saying? Religious liberty is a, quote, true remedy for religious discord. By relaxing harsh policies, we can break the cycle of tit-for-tat recriminations and lessen the fear, hostility, and resentment that would otherwise fester among religious groups vying for control of the state's coercive power. But in order to realize that goal, robust protections for religious liberty must be, quote, an equal and complete liberty. Translation, religious liberty has to apply to everyone. The major problem for religious liberty during the Reformation was that it was merely a means to an end. Religious liberty belonged to only the, quote, true religion, which was always your religion. Each side in a conflict would defend its religious liberty when it was being persecuted, only to switch its position when it controlled the levers of power. True, robust religious liberty can't just be for your tribe. It has to apply for everyone, including that group you may not like. That lesson holds true today. The fault lines and social divisions in our society aren't the same as 16th or 17th century England, but they're similar. We hear many of the same or similar charges against religious minorities today. Evangelicals are, quote, on the wrong side of history. Muslims can't be American citizens because, quote, they want to impose Sharia law. Native Americans need to stop complaining about the past and, quote, adapt to modern living. We do well to remember history's lessons. People of very different religious beliefs can be loyal citizens and good neighbors. But when we coerce, compel, or penalize religious beliefs and practices, there are enormous costs because religion matters enormously to its adherents. As Professor Laycock has said, history shows us that religion is, quote, important enough to die for, to suffer for, to rebel for, to emigrate for, to fight to control the government for. That's why government efforts to impose religious uniformity have been such bloody failures. How does this cash out in practice? It means religious liberty protects the right of Catholic foster agencies to work with families that align with their religious beliefs about marriage. That's Fulton versus City of Philadelphia. It means not imposing discriminatory permitting requirements to block expansion or construction of mosques and synagogues. That's the Murfreesboro Mosque. I mean, unfortunately, it happens way too often in Florida and New Jersey, all across the Northeast. It means respecting Native American sacred sites by not destroying them to build a copper mine. That's Apache Stronghold versus the United States. And it means repealing a state law that prohibits atheists from holding public office. That happened in Arkansas in 2011. In short, for religious liberty to serve its purposes, it must apply broadly and equally to all religions. That's the first requirement of a well-functioning religious liberty regime. The second is that religious liberty is not a general immunity from secular laws. Another way to put it is that religious liberty is typically not wholesale, it's retail. What do I mean? Religious liberty protections have to be robust because in order to serve its purpose in mitigating conflict, it has to be strong enough to allow people to organize their lives according to the most deeply held beliefs. But in order for us to maintain strong protections for religious liberty, limiting principles are absolutely necessary. So history, again, I think, provides a ready lesson. Following the American Revolution before ratification of the Constitution, the newly formed states adopted a number of state constitutional protections for free exercise. And those provisions typically limited the free exercise right to actions that would, quote, not disturb the peace and safety of the state. Professors McConnell, Laycock, and Barkley have persuasively argued that this was basically the 18th century precursor to our modern strict scrutiny regime. In colloquial terms, this simply means that the government has to have a really good reason to restrict or coerce religious beliefs and practices. Sometimes the government can make that showing, in cases like United States versus Lee or in drug cases where diversionary risks are real. But the point is that government must be put to the test before it can burden religious exercise. There are other limits that are important for mitigating polarization. Because protections for religious liberty are so strong, a religious believer seeking an exemption must have a sincerely held religious belief that's burdened. Unlike cases, say, under the Free Speech Clause, religious liberty doctrine actually cares quite a bit about your intent and interior beliefs and whether they're religious. This comes up very often in cases where secular self-interest collides with the religious beliefs. It's litigated, for example, often in prison cases involving kosher and halal meals or in lawsuits surrounding COVID-19 vaccinations. And finally, the scope of relief. That's what I mainly mean when I say religious liberty is typically not wholesale but retail. And in most cases, what religious liberty claimants are asking for is an accommodation or an exemption from a generally applicable law. They aren't asking for the law to be facially enjoined, but to prevent a particular application to them. Consider the Little Sisters of the Poor. The Little Sisters is a group of Catholic nuns who swear an oath of poverty and run nursing homes to take care of elderly patients who can't afford other options. In 2011, HHS passed a regulation as part of the Affordable Care Act requiring most employers, including the Little Sisters, to provide all FDA-approved contraceptives. The penalty was thousands of dollars in fines a day, which would have bankrupted the Little Sisters. And the administration exempted certain religious groups, but not the Little Sisters. And when the Little Sisters sued, they didn't seek to strike down the contraceptive mandate in total. They sought merely to get an accommodation for themselves, which they did. Similarly, in Mahmoud versus Taylor, a case that the Supreme Court is going to hear this term, involving parental rights, a coalition of Muslim, Protestant, and Orthodox Catholics and Orthodox Christians sued a public elementary school board. The school board decided to include and teach controversial gender and sexuality issues to elementary school students, but then removed long-standing notice and opt-out provisions. There, the Mahmoud family isn't seeking to stop their elementary school from teaching these subjects. They're just asking for an accommodation, notice and the ability to opt out for the child. Now, there are, of course, instances where relief does have to be wholesale. I'm thinking of cases like Masterpiece Cake Shop, Lukumi, Torcaso versus Watkins, and the Carson line of cases. But typically, we take the specific situation presented before the court, limit the areas of disagreement, and provide only the relief necessary to remove the burden on religious exercise. That also reduces polarization because each dispute over religious liberty doesn't have to be the fight that ends all fights. For example, I think it's often forgotten that in Gonzalez versus Ocentro, which is the Huasca case before the Supreme Court during the Bush administration, the court looked at specific uses of Huasca and its diversionary risks when assessing the government's interests. And even though it eventually ruled for the church, the injunction there was actually crafted in a very tailored way. The church had to obtain federal permits, had to restrict control of the tea to persons with church authority, and it had to allow an expedited process to suspend the permits. And in the wake of Ocentro, federal authorities were not hamstrung and unable to prosecute, say, for example, cocaine trafficking. To conclude, I want to end with where I began, which is the history. One of the reasons why I spend time on the history is because I think it's often misread. What do I mean? When we hear about the wars of religion, I think the lesson we often take away is that religion is inherently intolerant and prone to excesses. But secular ideologies have similarly caused immense human suffering. So what's the lesson? I think Professor Laycock again put it well. The evil of Reformation-era conflict was that the state sought with its coercive power and made human beings suffer for their religious belief and practice. The religious impulse is natural to human beings, so religion is natural to human society. People will go to great lengths in the teeth of official hostility to their religious beliefs, and government control of religion only seeds deeper conflict and creates more human suffering. Religious liberty is the antidote to this civil strife. taking religious liberty cases as they come, applying the doctrine even-handedly to people of all faiths, adjudicating cases based on the actual presented facts, balancing interests, fashioning the appropriate remedies are all part and parcel of a well-functioning religious liberty regime. And when religious liberty is done that way, it can calm fears, reduce hostility and resentment, and allow people with wildly divergent beliefs to live in peace with each other. Thank you.
Wow, these are great. As I was listening to them, I was trying to concoct a hypothetical that would integrate all of them and present a challenge to everybody. I'm gonna pose a couple of specific questions that are meant to be as polarizing and divisive as possible and see what this leads people. Zach Price favors approaches to interpretation that are neutral as between ideologies. My challenge to Zach is this. Does not the Constitution, by specifically protecting religious free exercise, embody a preference for religious ideologies over non-religious ideologies? In claims for exemption on the basis of conscience from generally applicable laws, and I think of the Masterpiece Cake Shop sort of scenario, would you extend accommodation to non-religious conscientious objections to serving same-sex marriages? And I'm going to let you think about that for a second. And my challenge to Brandon Paradise is kind of to flip the hypothetical. If you would preserve the right of institutions to advance diversity, equity, and inclusion on the basis of their religious conscientious support of these principles, would you similarly support the autonomy of a religious college to engage in functional discrimination on the basis of race, sex, or sexual orientation? And what I have in mind here is the case of Bob Jones University versus United States from 1983, involving an ostensibly Christian college, Christian university, that had a rule forbidding interracial marriage or dating. Would you similarly protect that freedom? So think about that for a second. Then I'll get to Joy Mosley, who believes in religious autonomy of religious institutions. I'm going to pose to you the same question. How do you come out on a case like Bob Jones University? Does the freedom to engage in religious exercise include the freedom to engage in divisive religious exercise? And then finally, Daniel, I'll pose a version of the same question. Daniel's thesis is that religious liberty decreases polarization. My reaction is, does it? Maybe, sometimes yes, sometimes no. What do you do when religious liberty, the autonomy of religious institutions, actually fuels divisiveness? Do you recognize it then? So let's go Zach, Brandon, Joy, Daniel, and just react to that, and then we'll discuss for just a few minutes before we go to audience questions.
Sure. Well, great questions, and really enjoyed all the presentations. So I guess I'd say a couple of things. So one is, the way I frame the principle as a second order value always gives me a bit of an out, which is, the Constitution does specifically protect religion, and sometimes, that's going to be asymmetric. Sometimes it's going to do work that other principles can't do. For instance, with free exercise, if you're talking about conduct, like consuming peyote, I don't think you can understand that as anything other than a religious exercise. If you can't repackage that as freedom of speech. And so there's just a protection there that is specific to religion. So I acknowledge that, but I do think there's a domain of cases, and I actually think Masterpiece Cake Shop is a good example where there's some choice in kind of doctrinal rationale, and I think the expressive freedom approach is better precisely because it's broader, and I think that's actually where the court ended up in 303 Creative. So, I think Masterpiece Cake Shop, I think it got to the right outcome in saying that someone providing a custom creative service could not be compelled by non-discrimination law to, endorse, celebrate a form of union that they find religiously and morally objectionable. So I think that's a sound principle, but I think it should go both ways. It should apply equally to someone who has a secular progressive worldview and doesn't want to be compelled to apply their creativity to endorse a contrary message. And the trouble is, because religion is itself implicated in that societal division, if you make it a religious specific principle the way Masterpiece Cake Shop did, and in fact did in a very narrow and confusing way, then you're kind of protecting one side of that divide and not the other. So I think where the court ended up later in 303 Creative is the better, sounder principle, because as the court said explicitly in the case, it said, look, this time it's a conservative Christian who doesn't want to provide custom websites for same-sex marriages, but next time it could be any number of other things. It could be the reverse scenario. And so that's the type of reasoning I think in principle should be helpful in this moment, where you can look at the case and say, okay, well, I don't like this outcome necessarily, but I see that the principle is equally beneficial for me. Now, I should say the court didn't get credit from everyone for that magnanimity, but I'm placing some trust in the fact that the sort of substance of the opinion in the long run will shape how people understand what the court is doing. So that's my general response. Let me just one brief thing about the broader points that came up in the discussion. So I think religious liberty is incredibly important, but for many of the reasons other speakers said, I think we want people to get their moral formation from someplace outside of politics and kind of come into politics on that basis. And I think liberal values can end up being just sort of empty if they're, in some ways I think the dynamic you see is if people try to make just the principle of tolerance and kind of open-mindedness the sole substance of their moral commitments, it can lead to some confusing places. It works a lot better if people have independent commitments and then accept that they need to tolerate difference, accept that other people have the same sorts of commitments and we all have to live in society. But I think my concern about, building out a jurisprudence that's religion-specific is that, rightly or wrongly, many people in our society, maybe my students, just view that as kind of hostile to them, as hostile to their own beliefs. So I think it's better to fold that protection for religious liberty into broader protections for expressive freedom and expressive association. I think that actually could put religious liberty on kind of firmer political foundations going forward, given where we are today.
Brandon?
So that's a really good question. It's a hard question. I would begin by emphasizing that First Amendment doctrine as we currently have it doesn't reflect the commitment to natural law and natural rights that I think dominated the founding era. And so one of the challenges we have when we talk about First Amendment doctrine is it does tend to relativize different types of religious claims so that religious freedom applies equally to all situations. When we go back to cases like Beeson versus Davis, where the court very clearly says that we denounce polygamy because it's inconsistent with Christian civilization. It's a 19th century case. I think it's very clear that even in the 19th century, there is support for more particularized moral judgments about the scope of religious liberty. So that I would begin by just wanting to distance myself a bit from contemporary jurisprudence, because I do think that there are mistakes with regard to the scope with which we provide religious liberty without regard to the moral activity that we're sanctioning. And then I would back up and I would say, well, why should the court be in a position to make judgments about what the scope of religious liberty is? I think that comes down to our capacity to make moral judgments, which are then bound up with knowledge about what is or is not a morally wrong activity. So racial discrimination has become, in our society, a very clearly morally problematic thing. So when we subject racial discrimination to strict scrutiny and say you need a compelling interest, it needs to be narrowly tailored, I think another way to understand that we've arrived at a consensus that Jim Crow segregation, which Bob Jones University was essentially doing in that case, is problematic, and that it's morally beyond the pale. Unfortunately, we are in a jurisprudential landscape where the court, unlike the 19th century court, is not going to make very strong claims along those lines. They tend to justify protections against racial discrimination in formalistic ways, and that's seen in the tiers of scrutiny that we employ. Now, with regard to why I would justify secular institutions' capacity to retain DEI, it is predicated on a similar point, which is that I see DEI as consistent with the search for knowledge. So the idea is that by including people from various walks of life and various backgrounds, we expand the sources from which we are drawing our empirical claims, and also the range of experiences that people have, which are not strictly speaking always empirical, because some aspects of our experience are functions of our subjective awareness, which does not necessarily mean that the things we're aware of are themselves subjective. But our awareness of things can be subjective. And so they're not strictly speaking empirical, but they're nonetheless very important to filling out our understandings of the world in which we live. So I would defend the academic freedom interest of institutions to carry out programs that include DEI along the lines of the teleological purpose of academic freedom, which I think really, just as the free speech clause, I really believe that a big role of free speech is the discovery of truth. Now, that's not the reason necessarily that the court always justifies it, but the discovery of truth is an important reason that we are committed to the free exchange of ideas, even though the court tends to justify free speech along a variety of rationales, and it's not always clear which one that they're rooting their jurisprudence in. By the same token, I would deny to Bob Jones University governmental subsidy for activities that we as a society deem to be morally beyond the pale. So I think that the problem here is, can we as a nation commit ourselves to very clear moral visions? Can we expressly state that racial discrimination is wrong? And I believe it's wrong objectively. You know, I would look at the nature of human beings, our shared rational faculties, and I would say that racial status and racial identity doesn't have any characteristic that bears on what makes us fundamentally entitled to rights protection. Our status as agents invested with dignity and protected by the equal application of the laws has nothing to do with racial color or skin color, right? Background or identity. On the other hand, I would say that the search for truth is deeply important, and we need to protect academic freedom if we're going to have a viable university system. Thank you.
Joy.
Yeah, so I think, Brandon spoke well about the strict scrutiny, meaning that not every religious claim automatically wins. That would actually contribute to polarization rather than depolarizing if just automatically religion won. And so there is a balancing test. And, Daniel in his talk mentioned some drug cases. There's also some tax cases where religion is lost, where they tried to claim my tax dollars shouldn't support a military, I'm a pacifist. So there is a balancing test. But your larger question about should religious liberty encompass divisive issues, I think the answer has to be yes. And what counts as divisive is going to be different for denominations, different for different traditions. Even at the CCC, we represent about 30 different denominations, and so we take kind of a broad approach to the different things that our institutions may choose to do. For example, we filed a brief supporting a school that held to a complementarian perspective as it relates to the role of pastors, and that only men should be pastors. And our president at the time, Shirley Hoekstra, is an egalitarian. But our personal view doesn't necessarily determine the breadth of the religious exception that we're going to support. And so when we think about, as I was arguing that moral formation is important, countercultural moral formation has to be a part of that. The freedom to believe countercultural things. Many religions, Christianity as well, you actually should look countercultural. Like, as Christians are called to look different from the world. And I tell schools sometimes the sexuality issues are kind of the issues du jour for a lot of institutions. But I tell them, if that's the only area in which you look different from the world, you actually have a theological problem. And so there is going to be a balancing test, but we do need to, in the larger scope of things, protect divisive, countercultural religious concepts, and then how that applies to specific instances will be determined through the judicial balancing test.
Daniel, your thoughts, and then get ready with your questions.
Yeah, I think religious liberty often can serve to reduce civil strife and to decrease polarization if, as I mentioned, it meets certain preconditions. And I think the biggest one is, again, that it's an equal and complete liberty. It applies to everyone, and I think that that's also a function not only of the free exercise clause, but also the establishment clause. It also, in many ways, applies to people with no religion. You can't coerce religious belief or non-belief. But I think it's also that religious liberty definitely, like, one of the justifications for it is reducing civil strife, but it's not its only one. I think religious liberty is grounded in many different justifications and principles. And again, like, I go to the Memorial and Remonstrance. James Madison said, "It is the duty of every man to render to the Creator such homage, and such only as he believes to be acceptable to him. That right is inalienable, because evidence that other people apprehend to convince them of religious truth might not be how you view it." And so there's a human dignity element to religious liberty, that it can't be coerced. There's functional or instrumental reasons. James Madison also mentions rule of law reasons, like you're going to respect the government more and the rule of law more if you feel like it's beneficent to you, that the government is treating you according to your rights. I think that's one of the things that happened in the Reformation, is that the argument was that you couldn't be a good citizen because you were a Protestant or you were a Catholic. But what happened was repression then bred a cycle over and over where people were persecuted, and then what happened in response was it became a self-fulfilling prophecy. So I think religious liberty, yes, it does serve to mitigate polarization, but there's also other good reasons for it besides just reducing civil strife.
We can go for about 10 minutes with questions before lunch, and we are standing by with the microphone, and Professor Berg is claiming the first question. Start us off, Tom.
A great presentation to everybody. Thank you. This is for Professor Price. What room is there for arguing, teaching people about symmetry that's more subtle or less direct than sort of this one clause that we're using in this case applies to everybody? So with religion, for example, you might say, well, as Daniel mentioned, there's an establishment clause as well as a free exercise clause. And even if it's not at issue in this case, it's part of this overall system of call it neutrality or whatever, towards religion. If we protect this right, we're also, there's also this other right that we're protecting. Now, maybe the court won't do that. Like if there's no guarantee that they're, say, going to protect LGBTQ rights at the same time as they protect religious freedom rights. So maybe that's the answer. But if there's symmetries at a larger level, is that sort of a part of your theory or your approach, or does, for practical reason or otherwise, do we need to be kind of confined or almost stuck with those provisions that are on the face of them for everyone? Does that make sense? Sure.
Just maybe it helps to group a few questions. I'm Amy Olin. You'll see us in the next panel. I also had this question going back to Professor Berg, your initial thoughts on kind of the impact of social media and the culture now and how it's different as we're moving through history. What happens when people can't even see the impact on others? And so it seems like many of these arguments depend on this notion that we have the empathetic capacity to understand what is the impact on people who are different than we are. But it seems like we're in a climate now, in many ways, where we can't even see each other, and we can't even see the impact that some of the rulings or the ways in which the culture is moving is having on others. And so I think each of your arguments depends on the capacity to see and perceive what happens when this hits someone who is different or who holds a different perspective. But I'm not sure we can fully assume that. And I would just be curious about how that impacts also how we think about teaching.
Zach, can you take all that on?
Sure. So, as with a lot of constitutional principles, there's a level of generality question with symmetry that I think you're getting at. I try to argue in the book that I think it works best in kind of the middle range, where you're talking either about a discrete protection or maybe a package of related protections like free exercise and establishment. And that's based on an intuition that it doesn't work as well at the two opposite ends. So I think the Supreme Court recently has tried to do a type of symmetry by kind of sprinkling some results that cut against the presumed political outlook of the court, but doing so in with kind of minimal reasoning. I'm thinking of things like the DACA repeal case and the census case from the first Trump administration. I think the problem is that approach to symmetry, if that's in fact what the court is doing, ends up looking, the cases look poorly reasoned, look kind of cynical, end up kind of inviting concerns about not following neutral legal principles rather than allaying them. I think then at the other extreme, I think if one's thinking about one's overall theory of interpretation, on some level you should want a kind of symmetric package. But I think partly because there's not agreement about any one correct theory, that's not necessarily going to produce a symmetric jurisprudence unless you're applying it at a lower level of generality. I also think that some people dispute this intuition, but I think you can see individual jurists like I think Justice Gorsuch is a great example, who has a kind of package of politically cross-cutting aspects of his jurisprudence with respect to, say, Native American rights and criminal procedure as opposed to administrative law. And he, for him, it's a coherent package. But I think it doesn't seem to me that he buys a lot of support for decisions that people don't like by having cross-cutting decisions in other areas. So I think it works symmetry works best when you're dealing with some kind of particular constitutional protection and trying to implement it in a way that makes that protection stable. I guess on the social media point, so I don't have a fully worked out theory, but I feel like social media is a big part of all these issues. And the way I think about it is that it makes it much harder for people to compartmentalize their lives. I think liberal society actually depends really importantly on people playing different roles with a kind of different role morality. I mean, judging is a great example. Like when you're a judge, there's a role morality associated with that societal function that doesn't carry over to how you conduct your family or any number of other things. I mean, even as professors, I mean, I think teaching is a different kind of set of role. There's a different role morality associated with teaching from engaging in scholarship, from let alone things in your private life. And I think one of the things social media does is it kind of collapses all those separate identities and encourages a form of kind of I would say sort of phony authenticity, where you need to get everything to line up, and in a very reductive way. And I think that, I'm not sure if that's a complete explanation for our problems, but I feel like that's one big asset, a driver of this kind of sense that we need a kind of mega political identity that everything I'm doing fits into, when in fact, you may be doing different things where you should approach them somewhat differently. So that's at least how I've been trying to think about it.
Do other members of the panel want to weigh in on any of these things? Let's go to Professor Fidel.
Thank you very much. Thank you for the presentations. I think I'd like to have a question to everybody, but there's no time. So I'll direct my question to Daniel. Just take a different point of view on the Establishment Clause and the Free Exercise Clause. You can think of the Establishment Clause, or at least I do, as protecting our negative liberty, and Free Exercise Clause as protecting our positive liberty. But at some point in time, there's got to be a clash between the two, because I maximize my positive liberty through establishment, but that's illegal, right? And so I think when you look at particular cases, for example, the case that you mentioned in Maryland, right? There's a clear attempt here, in my opinion, for a group of parents to maximize their positive liberty in inculcating their children in certain religious values, at the expense of the duty of schools to ensure an egalitarian, nurturing environment for every single student, regardless of their family type. And so, actually, from a state perspective, one might say, we're particularly concerned about those families who would withdraw their students, their children from this education. Those are the children that are most in need of this kind of education, because they are most likely to then be inculcated into some sort of bigotry in the house, right? And so I'm not trying to say as a religious matter, as a theological matter, that they are wrong. But I'm saying from a civic perspective, schools have to teach children tolerance. And religion oftentimes is a site of intolerance. And so there is it seems to me, an inescapable conflict here between the positive liberties of religious freedom and the negative liberties that we seek to have protected from the Establishment Clause. Sorry.
Can I help to frame this question for people who aren't familiar with the Mahmoud case? It is a parent's claim to withdraw from a portion of the public school curriculum based upon religious objections. Is it, could you explain what the religious objection is? And my understanding is they are not seeking to keep the school from teaching what the school wishes to teach. They just wish to exempt their children on religious freedom grounds from a portion of it. Is that right?
Yeah, so, can everyone hear me? So the Mahmoud case is exactly that. So ever since we've had like general sex ed requirements, I remember like going through that stuff, and like, for me, it was in middle school. There have always been a set of opt-outs because people understand on issues of sexuality, there's a lot of room for clash between traditional religious beliefs. And Professor Fidel's point is well taken, like even with like with like sex education, the whole point there was like, we want to teach safe sexual practices because kids might not be learning that at home when they were, especially if they're in traditional religious homes where abstinence is the only thing taught, and then some people think it wasn't effective. What's happening in Mahmoud is they're taking a step further and including, I think, pretty controversial gender, sexuality issues for like pre-K elementary school kids, like reading books, like saying like, oh, find like the lip ring, like leather, things like that, that I think I would argue is a step beyond teaching tolerance and teaching something akin to how do you teach tolerance to kids involving as to their gay classmates or transgender classmates. But your point is taken in the larger sense outside of the Mahmoud case, I think, in that like there are going to be these types of conflicts. And I think the school's argument is exactly that. They preserved opt-outs originally, notice and opt-outs, until they realized how many Muslim and Protestant and Orthodox families were going to claim them, and then they single-handedly got rid of them. And I think the argument is like, oh, we really need to teach the Muslims and the Christians how to like be tolerant. I don't share those thoughts. I think the way that like tolerance is a two-way street. And I'm not talking tolerance in the sense of, I'm talking tolerance in the sense of like people to people, because I think there's a difference between tolerance as like a legal political matter, which is very different from religious liberty. Tolerance assumes legislative grace, that the government can take a certain position, and that is just tolerating others. But I think for us, that is our position, where we have very strong, sincerely held beliefs, religious or otherwise, and we have to make room for other people. And sometimes that means like you recognize that parents are the best locus of teaching moral values to their children and not public schools.
Let me ask this of all the panelists. If you were to exempt parents, permit parents to exempt their children from a portion of the curriculum, would you only permit that on religious grounds, or would you permit the opt-out right based on any ideological disagreement with what the curriculum requires? Okay, I'm going to give you each 15 seconds to propound an answer, and then we'll go to lunch. So let's start Zach, Brandon, Joy, and Daniel, and then we'll be done.
So I think it's a very tricky issue for this reason, but I think I'd do it on broader ideological grounds if it's going to be allowed at all.
I would do it on broader ideological grounds, but I'd be uncomfortable making a judgment in the absence of more careful evaluation, which I don't think we have, of what exactly is in the particular curriculums that people are faced with. I mean, that's part of the challenge, is that these curriculums are often themselves not well rooted in reasoned analysis of what should be taught to begin with. So it's a big problem. But otherwise, I would just give a general, opt-out.
Joy.
Yeah, I would also give a more general opt-out and let parents make the decision if their concern is religious or conscience or whatever else, but let the parents make that decision.
I agree. I think Professor Paradise's reason is exactly right. I think it depends on like what the exact curriculum is, like how objectionable it is, how controversial it is, but I'm probably also in favor, like general opt-outs from specific public school curriculums have not been only religious-based. They've always been generally available.
And with that, let's thank our panelists for an excellent presentation. Thank you.
I want to just take a brief moment and introduce Reverend Jeff Tiemann. Jeff volunteers with Braver Angels and is the co-chair of the Reduce the Rancor Minnesota campaign to lower the political temperature during the election season and to build capacity for bridge building. He is a retired Lutheran pastor and former CEO of Portico Benefit Services, a ministry of the Evangelical Lutheran Church in America. He currently serves as the executive director for the Church Benefits Association and the Church Alliance to foster excellence in policy and practice for employee benefits for pastors, priests, rabbis, cantors, and lay workers in faith-based nonprofits. You can see more of his bio in the programs that you picked up on your way in this morning. So without any further ado, I will turn it over to Jeff. Thank you.
Great. All right. Well, thank you, Mason. Well, I am so excited to be here. I am going to talk to you, and we're going to do some demonstration and hopefully have some great fun together to learn about Braver Angels. And I'll tell you a little bit more about Braver Angels in a few minutes. But first, what I want to do is set the stage. We are about to witness a conversation at a local coffee shop between Nazifa and Paul. And they are going to talk about some changing events in our country. The background of this is a changed policy by Homeland Security. The policy for the last several decades has been that police, ICE raids would not happen in sensitive areas. And sensitive areas include churches, schools, and other places that have been designated as those sensitive areas. Again, there are exceptions to that, but they would not show up and do raids in those places. Recently, the Homeland Security issued a new policy that removed that protection. In other words, ICE raids can and have now occurred recently in churches and in other sensitive places. And so we're going to hear first, so that's a little bit of background, and then there has been a lawsuit led by a group of Friends Society, or Quakers, as they're commonly known. Quakers, the Conservative Baptist Fellowship, the Sikh Temple of Sacramento, California, have joined that lawsuit, suing the Department of Homeland Security over this policy, claiming that this new practice interferes with the free practice of religion and that it brings, fear to that environment. So that's a little bit of background, is this changed policy with Homeland Security and then this lawsuit. And I invite you to join Nazifa and Paul at their local coffee shop.
Well, some good news for a change. This country is finally doing exactly what it needs to be done to address illegal immigration, and not a moment too soon. Because for far too long, the leftist elite and their bleeding heart policies have handcuffed law enforcement, coddled illegal immigrants, and treated American sovereignty like some kind of joke. They cry about compassion while letting criminals flood across the border and expecting law-abiding Americans to foot the bill. President Trump, he's had enough of that nonsense. He's taken the gloves off, cutting through the bureaucracy, and bulldozing the ridiculous roadblocks that have protected lawbreakers over law-abiding citizens. No more loopholes, no more so-called protected areas where illegals get a free pass. ICE is finally doing what they're meant to do, enforce the law without leftist interference. We are taking our country back. Trump's strong, unapologetic stand on immigration is exactly why we elected him, to put America first, crush the lawlessness, and shut down the radical left's open border fantasy once and for all.
I cannot believe you're defending this. I'm with the Quakers on this and believe in the First Amendment protection of the free exercise of religion, but not you. You're supporting ICE, goons, storming into churches, ripping families apart while they're praying?
Oh, sorry.
How can you possibly think that's okay?
Give me a break. They're enforcing the law. What churches should be off limits for criminals now? If someone's here illegally, it doesn't matter if they're in a church, a school, or a grocery store.
This isn't about criminals. It's about basic human decency and religious liberty. People are being dragged out of religious services. You heard about Wilson Velasquez Cruz, right? ICE grabbed him right outside his church during worship.
And if he was here illegally, then ICE did their job. It's not like churches should be magical safe zones where laws don't apply.
For 30 years, our government agreed that places like churches and schools were off limits until there was an urgent reason. This new policy throws that out the window. You're cheering on a direct attack on religious freedom.
Religious freedom doesn't mean protecting people who broke the law. A church isn't a get out of jail free card. This is about keeping America safe. You'd rather protect protect illegal immigrants than follow the law?
Safe? Safe from what? These are peaceful people. You're letting fear-mongering justify armed agents standing outside churches. The Quaker lawsuit shows that Trump's evil policy is scaring people away from worshiping.
Come on, this isn't about religious freedom. The illegals shouldn't even be here in the first place. If someone was afraid of being arrested, maybe, just maybe, they shouldn't be breaking immigration laws.
This isn't just about them. You're attacking entire faith communities. These churches open their doors to everyone, and now you're supporting a policy that terrorizes people who just want to worship in peace?
Give me a break. No one is being terrorized. The only people who should be worried are the ones who shouldn't be here in the first place. You are blind to the real cause. They shouldn't be here in the first place. They shouldn't be here, period.
You just don't get it. Quaker worship depends on diversity, on bringing people, different people together. But now, people are too afraid to even walk through the doors. This policy is destroying that.
And you don't get it. Laws exist for a reason. If you don't want ICE in churches, then stop turning churches into safe houses for people breaking the law.
You are cheering on a policy that is turning places of peace into war zones. People are living in fear. And for what? Some political stunt to make it look like something is being done?
We are restoring law and order. If you don't like it, then maybe stop defending people who broke the law in the first place.
I can hardly stand to listen to what you're saying. You don't even care about the Constitution.
Ha! Deal with it. I do care about the Constitution and the right to free speech.
We've got a flag. We've got two flags on the play. Unnecessary roughness, dialogue interference. So that's where Braver Angels comes in. Braver Angels was started after the 2016 election when two of the co-founders, one in rural Ohio and one in Upper East Side, New York City, were talking with each other and said, it's like we're on different planets. You guys are talking like you're at a funeral, and here we're having a celebration. Wouldn't it be interesting to get 10 people that voted for Hillary Clinton and 10 people that voted for Donald Trump together and see if they could talk in a civilized way to better understand where they're coming from and how they see the world? They called up Bill Doherty, who is a retired local professor here at the U in family therapy, and told him about the idea. And Bill said, that sounds really interesting. What are you going to do? He goes, well, we were hoping you would figure that out. Well, they got together, they got those folks together, and really applying family therapy practices to conversations, then started what is now a nationwide movement that is going right at the heart of toxic polarization. Our view is that toxic polarization is the big problem that is keeping us from solving many other problems in our society. And so Braver Angels is focused on understanding, curiosity, having authentic disagreements. So real disagreements where we know where each other stand, but teaching people how to communicate, how to listen, and how to communicate so that their points get across. And where it exists, discovering common ground. I have met with thousands of people in workshops that I have been privileged to lead online across the country, with people around the world actually, and many here in Minnesota. Your institution, championed by your president, is a partner in our Reduce the Rancor campaign. You hopefully have seen the Reduce the Rancor Tommies commercials there. And we're very, very pleased. Your organization, your institution is really one of the leaders across about a dozen schools that are part of a little over 30 partners that we have across the state of Minnesota. So really, really good work. So very briefly, what we do is we do work with citizens and we do work with elected officials. So it's kind of two different areas. And in general, it's about communication. And what we do is we teach a set of communication skills. And I'm going to give you the very quick, and magically, while we're talking here,
Nazifa actually is taking an hour-and-a-half class, compressed it, and she is going to come back and demonstrate those skills for you. But we use the acronym LAPP, L-A-P-P. L stands for listen. A stands for acknowledge, so acknowledge what we heard. Most of the time we're listening in an argument, we're waiting for our chance to come in and show how stupid the other person is and how right we are in this polarized environment. So listen, acknowledge, where we acknowledge what we heard, and we encourage people to go deeper than the words on the policy, but listen for the emotions, the passion, the values that are driving people's perspectives. And then P is pivot. Pivot is like signaling before you change the lane, asking, I've thought about this a lot. Could I tell you what I've thought or what I'm thinking about this? And wait for them to let you, change lanes and change the direction. Then perspective is then stating your perspective very, very clearly. You heard Dean Kelly at the beginning and some others, talk a little bit about the history of polarization in our country. We today are at the highest level of polarization in this country since the 1850s. So now what's different about the polarization today, and you hopefully witness a little of this with Paul and Nazifa in their dialogue, and unfortunately, maybe you've seen this, because this toxic polarization is not something that happens anymore once every 4 years or every 2 years with an election. It has pervaded almost every part of our society, our churches, our schools, our families, our neighborhoods, our school boards, and so on and so forth. But what's different about the kind of polarization that we are experiencing today than in the 1850s? In the 1850s, the polarization was primarily ideological polarization. So that was around the issue of states' rights and slavery. Those are the two dominant ideologies. And then geographic polarization, the North and the South. What we're experiencing today, and it's been on a steep rise over the last 35 years. So this is relatively new, but it's not brand new. Over the last 35 years, we've seen a steep rise in what's called affective polarization. Affective polarization is particularly toxic because it is about how we feel about people that think differently than we do. There are 3 characteristics that I want to highlight for you to illustrate why this is so dangerous and why Braver Angels is so committed to working on this, because it is so damaging to our democracy, to our communities, to our families, and so on. Number 1, other. When affective polarization takes hold, we treat each other, we treat the opposite as other. And in the extreme, we exclude them, right? We expel them. With that other pushes people out of community. Secondly, we consider them to be unlikable and untrustworthy. So it has to do, again, with the feelings that we have. And when we treat people in ways that we don't like you, we don't trust you, you can see how that is so toxic in our relationships. And then thirdly, we challenge their morals. We consider them to be immoral. How could you possibly support a policy like that, a person like that, without being an immoral person? Now, when you add that up, that other, the treatment of other, that unlikability and untrustworthy, and the moral, considering them to be immoral compared to my superior morality, then what that does is it brings us to a point where failure or injury on the other side is almost as satisfactory and satisfying as success on my side. You see this play out in politics. You see this play out in other areas where there is an intent to damage the other side as much as move your side forward, and it is just causing great problems in our community and our democracy. So it is this affective polarization that has really drawn Braver Angels into this work because we believe, as I said, that we've got to address this. We can't do it on our own, and that's why I'm so pleased with the partnership with St. Thomas and others all across the state. It's primarily a volunteer-led organization. I'm a volunteer. There's nobody in Minnesota that gets paid to be part of this, but we've got a lot of volunteers. And our leadership at all levels in the organizations is balanced red and blue, right-leaning and left-leaning. And of course, we have independents as well. But we are not nonpartisan, or bipartisan. But in other words, what we do is we really seek to bring both sides in, and we go after issues of conflict. So with that introduction to Braver Angels, well, let's see if it works. Now we come back to version 2, where Nazifa has enthusiastically come back from her workshop where she's learned these skills, and we'll see how it impacts the conversation. Take it away.
Well, finally some good news. This country is finally doing exactly what needs to be done to address illegal immigration. Not a moment too soon. Because for far too long, the leftist elite and their bleeding heart policies have handcuffed law enforcement, coddled illegal immigrants, and treated American sovereignty like some kind of joke. They cry about compassion while letting criminals flood across the border and expecting law-abiding Americans to foot the bill. But President Trump, he's had enough of that nonsense. He's taken the gloves off, cutting through the bureaucracy, and bulldozing the ridiculous roadblocks that have protected lawbreakers over law-abiding citizens. No more loopholes, no more so-called protected areas where illegals get a free pass. ICE is finally doing what they were meant to do, enforce the law without leftist interference. We are taking our country back. Trump's strong, unapologetic stand on immigration is exactly why we elected him. To put America first, crush the lawlessness, and shut down the radical left's open border fantasy once and for all.
I hear how strongly you feel about this. You see Trump as finally enforcing immigration laws without loopholes, and you're frustrated that previous policies made it harder for ICE to do its job. You want fairness. People should follow the law, and there should be consequences when they don't.
Exactly. Tired of seeing people break the law and then get sympathy from bleeding heart liberals while hard-working Americans pay the price. It's just common sense. If you don't want to be deported, don't come here illegally.
I hear you. You're arguing that the law is the law and that we should apply it equally to everyone. And I actually agree. Rule of law matters.
Exactly. The rule of law matters, and I'm sick and tired of people breaking the law. That's why I call them illegals. And I'm disgusted with Americans helping break the law, even if they are going to church.
I've been thinking about how the law applies here. Can I give you my perspective?
Well, sure. I'm interested to see how you think the law applies here.
Here's where I see a major problem. This new government policy is breaking the law itself.
Breaking the law? Come on, ICE is literally enforcing the law.
I hear you saying that ICE is enforcing immigration law.
Yeah, finally, and with the gloves off. Exactly what needs to be done.
I can see you value strongly following our rules.
Of course, I'm a St. Thomas law student after all.
Are you open to hear how I see the law applying here?
Sure.
When it comes to the First Amendment, ICE is not following the law. The Quakers are suing Trump's administration because this ICE policy violates religious freedom, a constitutional right that's been protected and practiced for decades. Under long-standing federal policy, ICE was barred from targeting people in sensitive locations like churches unless there was an urgent reason. This wasn't some leftist loophole. It was put in place to uphold the Constitution, ensuring that people could freely worship without fear of government intrusion. That is the law.
Religious freedom doesn't mean you hide criminals in churches. That is supporting lawbreakers.
I hear that you want people to follow the law. I do too, including ICE and the administration. Religious freedom means that the government cannot interfere with religious exercise without an overwhelming justification. Look, even the Department of Homeland Security itself acknowledged that enforcement actions in religious spaces discourages people from attending services. That's a direct violation of First Amendment protections. This isn't just about immigration, it's about the dangerous precedent of government agencies disrupting religious practice. The Supreme Court has repeatedly ruled that attending religious services is at the very heart of religious liberty. If the government is going to override that right, it needs to be met with the strictest justification under the law. And DHS hasn't met that standard, not even close. That's why the Quakers are suing.
So you're saying it's not just about protecting immigrants, it's about protecting religious rights in general?
Exactly. The real question here isn't whether immigration laws should be enforced, it's how they're enforced without trampling over constitutional rights. Let's say ICE just started patrolling your church on Sundays, checking IDs at the door. Maybe they're looking for someone specific, but suddenly every single person in that church feels watched. That's what's happening to these faith communities. People aren't just afraid of being arrested, they're afraid to worship at all. That's a direct violation of religious liberty.
Okay, I'll admit, I wouldn't want government agents watching over my church either. But the law still has to be enforced.
I agree. Rule of law matters, and that's exactly why we should care about how it's enforced. How it is enforced is part of the rule of law that we both value. If ICE wants to arrest people, they should follow the legal process. But ending protected areas without oversight, that's a government overreach that threatens more than just immigration policy. It threatens religious freedom itself.
I still think Trump's right to be tough on immigration, but maybe I shouldn't be disrupting church services. That's a bit much.
See, we might not agree on everything, but we both care about law and order and constitutional rights. Maybe the real conversation shouldn't be about whether immigration laws should be enforced, but about how we do it without violating fundamental freedoms.
Yeah, I hadn't thought about it like that. I still think enforcing the law is important, but I see why people are pushing back.
That is all I ask. Just a conversation where we actually think through the consequences.
I do care about the Constitution and the right to free speech. I think we have more to say and hear about this issue.
All right, thank you. So, Nazifa and Paul, I want to ask you, before we let other people comment or ask questions, tell us, how was this experience for you in the two versions of the conversation?
Well, I think for me, in the first part, I was just like, I hate Paul. I can't, how can he think this way?
That effect.
And so, yeah, no, I'm just kidding. So I was just like, I almost didn't even hear what he was saying. It was more, he thinks this way, people are going to be, taken, and religious institutions can't be a safe house for people anymore, and all this like fear and, what have you. And so I felt this like kind of rage in my body. And then in the second part, I actually listened, and I think, through the script too, there was a identification of his values. Like, what does he value specifically? And then how can I talk to him? And I hope Paul felt heard. So.
Yeah, and for me, it's just like the first example, it doesn't feel like a discussion about ideas. It's more of, it devolves into an attack on people's character, or my character, and I have to defend who I am as a person, and it feels much more personal. Whereas if you actually take a chance to listen and understand someone else's position, understanding is like the first step to kind of maybe changing, but also you can respect the person more rather than develop some sort of me versus them attitude.
Thank you. I think it's very well said, both of you. And that affective polarization response that we have of bad feelings towards the other person, we know, as Nazifa said so clearly,
it makes it, I mean, you don't even want to be by the person. It makes it very hard to hear what the other person has to say, even explore their rationale, their values, where they're coming from, and that's not productive. And what we encourage in the work that we do is to have what we call accurate disagreement. You know, it's so easy, you can, we talked about social media earlier, you can just choose your version of reality to listen to, and what they'll do is they'll talk about how stupid the other side is and explain in the worst possible way what the other side is. And this happens both ways. We actually we have a term for this in Braver Angels, we call this outrage entrepreneurs. And the reality is that the outrage entrepreneur business model is based on likes and shares and views, and the more outrageous you are, the more likely it is that you can make money with that. So there's a real monetary driver in making it hard for us to then connect. But what we really try to do is have that accurate disagreement so that we can then move forward. And what I've heard from so many people is that, and you saw this illustrated in the second version, that they did find some common ground around the rule of law and the differentiation between the what and the how, and valuing both of those. And we see this over and over, that without asking people to manufacture it, in fact, we ask people clearly, do not manufacture, don't look for, don't seek common ground where it doesn't exist, but identify it where it does exist. And that happens over and over. Any other comments? Was anything hard for you or easier? What was hard, what was easy? And I know you had the whole script in front of you, but if you put yourself back into your characters, what part of this was hard in the second version, and what came easy to?
I think the first version was too easy for me to be comfortable with, but I don't know. It definitely, like, even when you're pretending or acting, like, it's still, like, the body language, it's hard to, it's like natural. So I guess the emotion in the body language is real, so it's different, or difficult to separate that a little bit.
I think part of the thing for me that stood out was in the first part, like I literally kind of shifted my body and was like, I don't want to see Paul. And so like that was something that stood out to me, is like you literally separate yourself and then dialogue ends. But then for the second part, I had to take a pause for a second to digest what Paul was saying, and then just like wait for a moment, because I think it's natural to kind of have reactions, but it's then how you lead with it that can change the conversation. And so that was interesting.
Yeah, so I love what you both said, that we have these natural tendencies to just go into the fight mode when we hear this, that is, or as you said, Nazifa, just shut off. That's that othering, right? I'm going to exclude that person from my life, those people. But we're talking half the country, right? We're talking half the country went one way, half the other country. We're not going to solve these problems by excluding those people, because that's half of us. It's hard work to do that. You also mentioned the pacing. We talk a lot about that in Braver Angels, because what happens is we get at such a speed in these arguments that are not intended to understand each other. They're just bludgeoning arguments with each other. And if we can slow down and pace, what we know is that when people then have that space to be intentional about their next response, it can make all the difference in the world. Now, you saw Paul shift dramatically in this. That doesn't always happen. But we have also found that when one person learns these skills and then practices them, they then get repeated because that first person is modeling it. And so I talk to people about never underestimate the impact, the power, the influence that you can have by having these conversations in a different way, because people individually actually have a lot of power to change the way this happens. I am curious, any questions or reactions about either this specific set of illustrations or about Braver Angels in general? We've got a few more minutes, I think, available, and would be happy to answer more questions.
So you, at Brave Angels, thanks very much for this, by the way. You do sort of careful structuring of the opportunities for people to dialogue. What do we do when, we're in other settings like social media and so on? I guess applying these principles in those settings matters, can work too, but what does the organization sort of say about how to bring these into the spheres where they're not nearly as natural and not as easily set up?
Thank you. So we talk about using these skills in a lot of different areas. In group conversations, we have a workshop called Families and Politics, because what you have is the combination of family systems and toxic political polarization. And that can be an especially toxic, challenging mix. And then we have workshops that we do with elected officials called Managing Difficult Conversations with Constituents and Colleagues. And so there are many different settings in which these skills can work. We also have a workshop on social media, using these skills in social media. But to go back to answer your question specifically, what we do is we recommend that people, and our classes are very experiential. They're online and in person, and they're very experiential, and it's really built around an adult learning model of experience and learning from each other. And what we recommend then is to take that out, identify a couple things that you're going to take out, and practice it, start with it one-on-one. It's just easier, because what happens is if you do it with a group, it's easier to get ganged up on, right? I mean, you might be the depolarizer at your table surrounded by 2, 8, whatever polarizers that are just going to pounce on you. So the first start is do it one-on-one, and then and it works better in person than mediated, especially with social media where you're not really interacting. But we recognize the important role of social media. That's why we have that class on social media. I happen to really love this stuff. I've been volunteering for about 6 years, and sometimes have a masochistic approach on it. And so I have on purpose waded into social media contentious conversations where I have a view on that topic, and really work hard to try to practice the Braver Angels methodology in those. And it's really I find it fun. It doesn't always work, but it often works. And so this is something I've been working at in contentious social media. I find it works better on Facebook than on Twitter, because Twitter or X is I don't know, it's so temporary, right? You throw your flame in there and you're moving off and you're throwing grenades elsewhere. Facebook is more like, what I've experienced, is more likely to be a place where people will engage in conversations. But it is absolutely true, it's much more difficult. I've also found that, I just had a great conversation with my brother-in-law last month, and I said, Mark, I'd really like to hear your views, and I kind of explained where I was coming from. And he stopped, and we've known each other for 25 years. And he goes, well, Jeff, before we get into this, I want to know, are you asking because you're seriously interested, or are you trying to make me look stupid? And you're just going to try and paint me into the corner and and humiliate me. Now and we had a strong relationship, but this is not easy work. And so there is that sense that to make this really work, that sense of trust, openness, curiosity, sincerity is really important. If you're not going to bring that in there, it's probably not going to work. I would also say that I found these skills to be useful in so many settings. As many of you are preparing for careers in law, I think, I'm not a lawyer, but I just think about how valuable it is to be able to deeply understand different perspectives on the issue that you're involved in. And when you can deeply understand, again, not just at a policy level, but at an emotional level, at a values level, at a personal history level, number one, you can develop a deep connection with someone on the other side, understand where they're coming from, and if you are in an opposing argument situation, I think you're much better prepared than for that situation. I just think that there's a ton of benefits, but I also think that and I've seen this, that we have a great impact. We do surveys after every single one of our workshops. We have skills workshops and we have experiential workshops. I know you're going to have a talk in just a little bit about the conflict in Israel, Palestine, Gaza, that area. We have what are called one-on-one conversations. You can go to our website, braveangels.org, and you can say, I'm on the Palestinian side of this, or I'm on the Israeli side of this. I'd like to have a structured one-on-one conversation with somebody on the other side. And we've got a conversation guide. The Palestinian-Israeli one is one of our newest ones. It's actually quite popular, as you probably would not be surprised to hear. But we really believe in helping people dive into these with skills training, but also experiences that work. All right, that's a really long question to your short, really long answer to your short question. I'll try to be briefer next time.
So thank you so much. That was such a wonderful example you gave us of conflict resolution. So you talked about 1850, right? 1850 led to a civil war.
Exactly.
Right? Well, would reducing effective polarization in that context have changed the problem of slavery? I mean, so my basic, question is, even if we assume it's good, which I think it is, to reduce the demonization of a conversation partner, because ultimately we would want to change their mind and convert them to a new point of view, will the reduction in effective polarization itself, is there any evidence that leads to concrete policy changes? I mean, so your third example, we tend to think of the conversation partner as immoral. That actually might be true. It might be true that the person is themselves, right, immoral and committed to an immoral view. So if you're a slaveholder and you're committed to enslaving other people and you're committed to their dehumanization because you don't believe they're equal, I think your view is immoral, and you yourself might well be guilty of immoral activity, immoral practices. So my point there is just to say that I agree that reducing unnecessary conflict is a good thing, but sometimes conflict is necessary. Sometimes it's absolutely necessary to condemn the views that people have, because we need to change the policy, not simply have a more polite conversation, right? So what is the view of Braver Angels with regard to changing policy?
Yeah, so I would, I agree with so much of what you said. And what I would say is a few things. One is that without relationships and dialogue and understanding and the ability to hear where the other person is coming from and then provide a different perspective, it's less likely that your perspective will be heard. And so if I was, we were both in the 1850s, I was a slaveholder and you were opposed to slavery, we would have to build some rapport for me to be able to even hear you. Now, with that though, our experience within Braver Angels is, if you think about kind of the political spectrum, what we have not been able to do is bring the far right and left extremes into Braver Angels. And I don't know if our approach is an approach that will ever bring them in. But we do know that we can bring the next tier in from there and the people that they are talking to. So that's what we work on. So I think that that's a really sticky problem to, where you have something where it is a question of morality, like enslaving people, where the solution is to fight that immorality and get it behind us. And that's hard to do because you often have those two extremes. You have to defeat them. I would hope that for the problems that our country is facing today, we would not have to turn to violence as the way to solve them. So that's another tenet with Braver Angels. Very briefly, I will just, I could give you so many examples of where this has worked to bring people together. One of our workshops is called Common Ground, and we bring people together around a particular issue from opposite sides. I've done this we recruited people out of a Second Amendment group, very, very strong Second Amendment rights group, and we had a leader in that group recruit folks there. And then we had the father of the first Craigslist murder. His daughter was shot responding to a Craigslist ad. And he has gone on to really try to advocate sensible gun laws to address gun violence. So we brought those together, and the outcome of a Common Ground workshop is that list of values, concerns, and policies that have unanimous agreement. Now you think about bringing those two groups together, that's going to be about zero, right? That Venn diagram will be zero things. Typically it's 25 to 35 things is what I've found. And so I've done these workshops all over the country and all over the state on immigration, gun rights, mineral rights, how to teach about racism in Georgia public schools and so on. And it's just amazing how this happens. But that's not the last step. In El Segundo, California, so it's east of San Francisco, they had, and still have somewhat, but not to the same degree that they had a real problem around homelessness. And they organized, the Brave Angels folks organized a Common Ground workshop, and without getting all the details, there are several dominant theories about how to address homelessness that are, they just compete with each other. But they got people from those different groups together, and then starting with that, with some agreed upon policies, went to the government officials and then agreed on policies and implemented some things that have made a huge impact on homelessness in El Segundo. And El Sobrante, sorry, it's El Sobrante, not El Segundo. El Sobrante is the community. Anyway, and there are lots of examples around that. So will this fix everything, especially on those extremes? That is really challenging. And I'm not going to stand here and say I've got the magic bullet or the magic wand to fix that one. But we know that if we can come in one rung inside of the extremes, we have found it very, very effective. And the impact, in one of the metrics that we have is the last data I've seen over several years of data is 87% of our workshop attendees you basically say they feel more confident in using these skills. And I'm a pastor, I'm a retired pastor. I think if I could preach a sermon, have 87% of my congregation, walk out with changed hearts and changed minds, like that's a win, right? So it's not very often that you get an 87% hit rate on things like that. We've had academic studies. So we know that within that it really works, and there's more work to be done. And I invite you to all be part of that other work.
Thank you for the demonstration. A lot of what I want to say, Brandon already said, but I think the other thing that I'm worried about, I think we talked about this privately here, is the difficulty of scaling this approach. On the one hand, people who are even willing to participate in this are already sort of willing to treat others as free and equal people. And so you kind of got a bias sample problem because the people who are participating have already indicated a certain kind of goodwill and desire to have some kind of civic friendship with the other. The The problem is with the people who are unwilling to have civic friendship. Oftentimes because it's a principled objection to having civic friendship with the other. This is sort of what Brandon was talking about, where you have groups that have a principled, although we deem it to be immoral, they nevertheless think they are acting on the basis of principle in excluding this other group. And so they don't have to listen because they might be in a position of social power. Because they're in a position of social power, they can just ignore the complaints of others. I mean, can you imagine Bull Connor sitting with Martin Luther King and having a discussion about equal right of desegregation? It's inconceivable, right? It's just inconceivable because of the disparate power relations between the two. And so how do we overcome this problem, this sociological problem of power discrepancies between the privileged and the marginalized in order to have an idealized conversation on a scale that could make any kind of salient difference to our politics?
Yeah, and the whole scale is an issue that we've been talking a lot about. And then the Reduce the Rancor campaign, really, part of it was around building up scale here in the state of Minnesota. And so we're seeing this. We've got a little over a dozen college and universities that are on board, and some of them have taken this idea and asked, how are we going to change the way the entire education experience is? So how does this impact the classroom? How does this impact living spaces and community life and so on? And what is gratifying there is that we're seeing, bridge builders being trained in a world where the bridges have been burned down. I'm not going to say that this is going to work in every situation, but where we have been able to get people together, it works. You're exactly right that there are people that are, more likely to attend this than not. One of the areas where we have been able to get what you might think of as the normally unwilling to participate are places like school boards, city councils, county commissioners, where this becomes part of the education there. And so I've done a number of school board training, but we've done a number of those elected leader trainings. And I've seen some good results where school board meetings have changed in terms of how they're able to interact. But unfortunately, you also have kind of the proponents of outrage that are still on the sidelines, edging on their elected person to do this. I'll just close. I think Mason gave me the 5-minute wrap-up warning. So first of all, I appreciate the questions, and I will say, as you are observing, this is challenging work. This is hard work. We call ourselves braver angels because it requires courage to step in and do this work. And the further extreme people are, it is harder to engage them. It's more difficult to practice these skills. But I don't know that there's a better alternative to treating them as, from a human being perspective with respect and hearing them out, listening to their perspective, their values, their stories, and doing that in a way that also makes it more likely that they will hear mine. And when that is done, I have just seen so many hearts opened to hearing and respecting the other that I'm convinced that there's a lot of value in this work, and I will never claim that this will solve all of our problems, but this is a key part of doing that. And yes, we need scale. And so call this a recruiting talk. Please join us, braverangels.org. And however you choose to engage in this work of depolarizing this toxic polarization, I'm cheering for you to do that. And I'm committed to do this as well. So thank you very much.
Please help me welcome onto the stage Professor David Schraub, on Zoom, which should be showing up on both sides here. There he is. Professor Mohammed Fadl and Dr. Amy Ullman. Professor David Schraub is an associate professor of law at Lewis and Clark Law School in Portland, Oregon, where he teaches and writes in the areas of constitutional law and anti-discrimination law. His particular focus is on contemporary issues of racism and anti-Semitism. He holds a BA from Carleton College, a JD from the University of Chicago Law School, and a PhD in political science from the University of California, Berkeley. Seated on the far left of the stage over here, my left, I guess, your right, is Professor Mohammed Fadel. He's a professor at the University of Toronto Law School, which he joined in January 2006. Professor Fadel received his PhD from the University of Chicago and his JD from the University of Virginia School of Law. He has published numerous articles in Islamic legal history, Islam and liberalism, contemporary Islamic legal reform movements, and international law. And last, and certainly not least, is our moderator and co-panelist for this event, Dr. Amy Ullman. I hope I got that right. Dr. Amy Ullman is the Director for Mission and Ministry at Georgetown Law, where she also serves as a lecturer in religion and professional life, a special advisor to the Dean, and a senior research fellow with the Berkeley Center for Religion, Peace, and World Affairs. Dr. Ullman's BA, JD, and SJD are all from Georgetown, and she holds an MA in theology from Fordham. In addition to research in Catholic social thought and the law, her current focus for teaching and scholarship is fostering pedagogical practices and communication skills to address religious and political polarizations in a variety of settings. Now, I summarized their bios, which are more extensively outlined, so you can read more about our distinguished panelists in the programs that you all have at your tables. There will be time at the end for question and answer from the audience members, so please feel free to jot down anything, and then we'll open it up towards the end. But without any further ado, I'll hand it over to you. Thank you.
Great. Thank you so much, Mason. And thank you to all the students. Thank you to all the students for being here on a Friday afternoon, right? And for all of the amazing work that you have put into this conference. Brandon, Professor Paradise was just saying, oh, this is the hardest topic. And I said, no, this is not going to be, well, I don't want to overpromise. But when we got on the Zoom to prepare with Professor Berg, there was such a wonderful kind of chemistry of ideas and exchange, and I found myself desiring more time together. And so I'm hoping that this feels like that kind of conversation where we're able to open out what we want to acknowledge as very hard questions, and a few insights from the work that we've been doing, our own teaching, our own scholarship, a few insights for maybe not so much how to answer those questions, but how to frame them and how to open out more in-depth work in this area. And so we thought to proceed like this. We each aim to keep our initial ideas short so that there's plenty of time to interact first with each other, because we do have different perspectives, and then plenty of time, and we're hoping also you can integrate your questions and your insights that might have emerged from the very, very rich, deep conversation this morning as well. So we're hoping to leave enough time for that. So without further ado, Professor Fadel, you want to get us started? Yeah.
You want me to go first on this? Okay. Mason, did you want to put up my slide? I don't know how this works.
Sorry, one second, please.
Okay, let me.
Yeah, we see David in front of us, and it's nice to see you, David. So.
I'll be back.
Okay, now ready. There it is.
Let me get started. Okay. Okay, let me get started. Thank you so much for inviting me. I really wish Esma were here. I think she was the one that thought to bring me here, so I really appreciate the generous invitation to come and speak to you and share with you some of my ideas about the First Amendment and the Palestine issue and the conundrum that we face today. Now, I do think, I want to start by tying my remarks to this problem of polarization. And unfortunately, despite some of the comments from the previous panel about the role of the First Amendment in promoting diversity and promoting a kind of civic tolerance, I think in reality, at least in the last 20 years, our First Amendment jurisprudence, particularly what I call free exercise inflation, has led to quite the opposite. And the reason why is because instead of reading things like substantially burden a person's exercise of religion, this is from RFRA, in an objective fashion, courts have essentially given religious claimants subjective license to define religion in any way they wish, without any obligation to explain why a particular regulation is a substantial burden, much less how it relates to their entire exercise of religion. So these things are completely, they're sort of pro forma hurdles in cases, and instead we focus entirely on the compelling burden, the compelling interest part of the RFRA thing. And I think here there's an asymmetry. The definition of exercise of religion is defined quite narrowly, so that any restriction turns out to be substantial, because if you define the practice narrowly enough, well then it's virtually a one-to-one, the religious practice being the numerator and religion, exercise of religion being the denominator. If they are the same, then it's substantial because it's 100%. Whereas the government's interest tends to be defined broadly, and so it looks like the government has other ways of achieving its aims. I don't want to spend too much time on this because that's not the main focus. But what I want to say is that this has created a culture, I think, of religious extremism, in which all sorts of claims that would otherwise not work from a political perspective can get redressed as a religious claim and get traction. And I think that's essentially what's going on in the case of anti-Semitism as being applied to Palestinian advocacy. So issues of Palestine advocacy are no longer being challenged as a political idea, but they're being redressed as a violation of the religious freedom of Jews. And I think that's a very dangerous development, and I really hope that American Zionists, at least who are committed to some form of liberal governance, rethink their approach on this. Now, with respect to speech and expression and the First Amendment, I think we need to think carefully about what are the purposes of the First Amendment. Are they intended, is it to mobilize your political allies, or is it to reach a common agreement through deliberation in furtherance of a project of civic friendship, right? So I take the latter view. Now, if you take the latter view, that First Amendment is about promoting a culture of civic friendship among citizens, then that entails, that requires not just a right, the freedom to express yourself or freedom to worship the way you wish. Of course it does. But it also requires, particularly with respect to the freedom of expression, a duty to listen in good faith to what other people say, to follow evidence, to make judgments based on science, sort of more or less broadly understood, as opposed to passion and desire and interest. So I'm going to shift now a little bit on my views here because I'm Rawlsian, and so I think the ideal of public reason is very important, because the ideal of public reason implicitly incorporates this duty to listen. And how does it do so? Because it tells us that as reasonable citizens, we only offer terms of cooperation that we reasonably believe others as free and equal would reasonably accept. So we don't make political claims without first asking ourselves, are my other fellow citizens viewed as equals to myself, reasonably prepared to accept what I am offering? And if I recognize that there's no way they could do that, then I won't make the offer. Right? So public reason has the virtue, all other criticisms aside, of promoting a certain kind of internal virtue of restraint and moderation in one's political demands. And I think it would be very good if we taught that as a value with respect to claims under the First Amendment. Right? But in order for this to work, we must have a moral commitment to view others as an equal, and a willingness to consider and weigh evidence in an objective fashion. The reality is, as we've been talking about, there are lots of segments of the population that are unwilling to recognize their opponents as their moral equals, right? And therefore, they are unwilling to consider actual evidence. In a recent paper of mine, I offer a Rawlsian critique of liberal Zionism precisely for its failure to take Palestinian equality seriously. It argues that to take Palestinian equality seriously would require it to accept public international law as the baseline for any kind of settlement of the conflict. And accordingly, the demands of Zionism must be limited by the duty to treat Palestinians as equals. Now, if we accepted that premise, I think we could make a lot of progress toward peace and, as I said, civic friendship. Now, the paper concludes with very specific proposals that would reform the basic structure of the Israeli state, from one that entrenches Jewish domination into one based on equality of all its citizens. And I can get into those later because I'm running out of time. But I think what's very important here is that some things that are crucial to the current structure of Israel, such as the Jewish National Fund, would need to be dissolved. That any kind of partition would have to recognize Arabs and Jews as equally constituent peoples, having equal constituent power, right? That any kind of partition would have to effectively recognize the equality of rights of both peoples, wherever they may be in the geography of Palestine, that there would have to be a public culture that recognizes the equality of both Arabs and Jews. In other words, it would require a reconstitution of Israel in the same way the United States was reconstituted after the Civil War. Now, this is not a threat to Jews, right? This is a promotion of equality of Palestinians. So I teach a class on the law of Israel and Palestine in my law school. I've taught it for 2 years. I co-teach it with an Israeli Jew. And this is what he puts. He says, it is not anti-Israel. He's Israeli. He served in the Israeli army. His view simply is that what we are demanding is a reconstitution of the Israeli state to make it a state based on equality rather than Jewish domination. So I'll stop. Thank you.
Thank you so much, Mohammed. And we'll jump right in with David. And he's on the Zoom. Yes.
Thank you so much, and I'm very, very grateful, not just to be invited, but for the flexibility to allow me to do this remotely. I have a 2-month-old baby in the other room who is just the best little distraction from the world right now, which is very sorely needed. But I'm really glad to be here, even if over Zoom. And what I want to focus my talk about, it's these questions of free speech on campus. And if there's one thing that pro-Israel and pro-Palestine campus stakeholders have in common, it's that on matters of campus free speech, they really both are presenting themselves as victims. Pro-Israel commentators argue that Jewish and/or Israeli students, or those who are seen as aligned with them, are systematically ostracized, targeted for harassment, discrimination, exclusion, in an attempt to silence their perspectives and extirpate them from academic circles. Some claim vectors for these attacks include no platforming rules targeting Zionists, but often enforced with a very special vigor on Jewish students who face heightened scrutiny and review, academic boycotts targeting Israeli scholars or persons who seek to work in Israel, or ideological litmus tests where certain departments or academic units refuse to countenance quote-unquote Zionist perspectives amongst hires, lecture invitees, symposium participants. Meanwhile, pro-Palestine commentators simultaneously argue there is a Palestine exception to free speech rules, where Palestinian or Muslim students, or those seen as aligned with them, are systematically deprived of the academic freedom and constitutional protections they're entitled to when their speech is deemed too harsh in its criticism of Israel or Zionism. And claim vectors of these deprivations include things like cancellation of pro-Palestine events, speeches on campus, overly harsh enforcement of campus disciplinary rules, and most recently, arrests and threatened deportation of pro-Palestinian international students. So how do these cross-cutting sets of grievances relate to one another? Things move very fast in this line of work, and I was originally invited to this panel in October of 2024. That was 5 months ago. A lot has happened in the ensuing 5 months. A lot has happened in the ensuing 2 weeks, or last 2 weeks. And in particular, we've seen, I think it has to be noted, a dramatic escalation of state censorial power directed by the Trump administration against pro-Palestinian students. Much of this, I think, is a stalking horse for a larger assault on higher education, and the putative justification of fighting anti-Semitism is really just a form of using, frankly, Jews as human shields to take the blame for Trump's own actions and own attacks, broader attack on higher ed. So I'll try to address, especially in our conversation or back and forth, how these more recent developments do and don't change the analysis I'm about to give. But for now, I just want to acknowledge that the circumstances that prevailed when I started writing this talk and the circumstances that prevail now are materially different. But the framing device I want to use for my talk is a campus climate survey that was done in October of 2024 at the University of Washington. And one of the most interesting and frankly depressing findings in the survey, and in my line of work, every interesting finding, it seems, is a depressing one, is that they asked Israeli, Jewish, Arab, Muslim, and Palestinian community members whether UW was a comfortable environment for various groups, for themselves, but also for other groups. I'm going to share the resulting table, which hopefully you can see, but I'll also describe it. Basically, the Arab, Muslim, Palestinian respondents more or less said that UW is not comfortable for Arabs, Muslims, and Palestinians, but they said it's a very comfortable environment for Israelis and Jews. And Israeli and Jewish respondents said it's not at all comfortable for Israeli and Jews, but it's a comfortable environment for Arab, Muslims, and Palestinians. So we can sum it up as saying, we're suffering, they're doing great. Both sides. And so what gives? Assuming we don't want to say that one group or the other is just simply wrong or lying about their own experience, which I think we should be reticent to do, what are some explanations for these cross-cutting senses? And I don't know if I want to how much detail I want to go into now versus in our conversation, but I'm going to forward two possible explanations that I think are worth parsing through. One is a way that how in our society being hurt or vulnerable generates claims. Claims for empathy, care, concern, solidarity, and so on, which I think is a good thing. But it does mean that there is an incentive to deny the pain of others so they don't gain access to that claim for empathy, care, solidarity, and so on. And so you have this impulse to deny the vulnerability or downplay the vulnerability of others, particularly when various care resources are viewed as zero-sum, or when we worry that the alleged causes behind another group's vulnerability are practices, strategies, arguments that we find valuable, that we're using for our own projects, and we worry that even acknowledging the vulnerability of the other might mean having to adjust or even abandon a political tactic that we find dear ourselves. And so
can we bring David back to the full screen just so we can see you better? There we go. Great.
And so we can always argue that the challenge practice or what have you is justified, even notwithstanding another group's objection, but often it's just easier to undercut the claim's social force by successfully denying the underlying kind of allegation of marginalization at all. And these cross-cutting denials are ways of kind of knocking out what Muhammad said was very important, and I agree is very important. Knocking out a potentially uncomfortable or challenging claim from the category of those that command social attention. It's a way of not listening. The other possibility, though, I want to forward, and I'll discuss this briefly and then maybe we can go into our conversation, is that there are different modalities of feeling censored or having your free speech threatened, that as generalizations are targeting pro-Palestinian versus Zionist pro-Israeli speech. And so focusing on one mode means it's very easy to kind of overlook or not see the other. And so in this register, we can distinguish between threats to free speech from what I'll say above and below. Above meaning de jure sanctions by legal or quasi-legal actors, putting formal penalties, government, university administrations, for example. Whereas below, social sanctions, ostracisms, blacklists, no platforming rules by peer groups or civil society members that don't have the official authority to, find you, throw you in jail. And my generalization is that much of the cases of alleged anti-Palestinian censorship comes from above. Much of the alleged anti-Israel free speech threats comes from below. There are absolutely exceptions. I can go into some of these exceptions, particularly when we remember that not every social space is the UC Berkeley Anthropology Department, and not every government is the United States under the Trump administration. But as generalizations, I think there is something worth talking about here. And while from above censorship is what we often think of when we talk about censorship, the First Amendment targeting government penalties that in turn are targeting bad speech. And academic freedom often sounds in this register. It's about preventing the university administration from punishing you, taking away your tenure, firing you if you say the wrong thing. If we remember our Foucault, power comes from below, right? Efforts to discipline speech can be, in fact, sometimes more comprehensive and far-reaching than formal attempts to punish it. The regulatory tools are very powerful, but also very blunt, right? And therefore have limits in scope that aren't necessarily replicated by distributed social sanctions that are more comprehensive in effect without having easily identifiable singular nexus points for origination or clear abusive power. And so John Stuart Mill on liberty, and this is the last thing I will say before we go to the conversation, he's our go-to text for opposing from above de jure censorship. But in On Liberty, he actually suggests that informal social tyranny is maybe more dangerous than the expressly juridical kind. He says, since, though not usually upheld by such extreme penalties, it leaves fewer means of escape, penetrating much more deeply into the details of life and enslaving the soul itself. Mill strikingly refers to this as the despotism of custom. And when he articulates his harm principle, he actually places the moral coercion of public opinion on the same terrain as physical force in the form of legal penalties. Both represent forms of societal compulsion and control, and therefore both are subjected to the rules of the harm principle. How one plays those out, right, is going to be different, and it's going to be difficult in both cases, particularly since both forms of threat can't be attacked categorically. There are situations when they are justified. We are legally fine with restrictions on speech for things like threats or incitement or defamation, as well as content-neutral time, place, and manner restrictions. And on the customary level, we are fine with, we in fact encourage social penalties for certain forms of bad speech. The Holocaust deniers should be shunned, right? And that's often presented as the preferred remedy for bad speech in opposition to legal penalization, particularly since this tyranny of custom is really hard to distinguish from just a normal negative evaluative appraisal and counter speech saying, I've listened to what you're saying, I think it's a bad argument. We can't punish that. We can't view that as a threat to free speech. So there's a lot of blurriness here, and I think that blurriness creates the space for this sort of dueling sensibilities of I am being hurt and unjustly, targeted while they're doing fine. And so when we kind of identify, though, these different modalities of potential threats to free speech, right, we can see that neither group is lying about their own experience. They're both onto something real, and we can maybe develop a more empathic and broad-ranging understanding of what's necessary to create this space of open dialogue and freedom to listen that I agree is essential in all aspects of academic life, but maybe especially essential here.
Fantastic. Thank you, David. There's applause here. and I think, thank you also for the effort to be present in the room, because we can feel that you are really here. So thank you so much. What I'd like to do is just add a couple of more along the lines of questions about how do we respond to, I think the shared tension and question is how subjective experience of feeling ostracized or feeling unsafe or feeling this is not a hospitable environment looms very, very large, right? Very large, whether it's in the religious freedom arguments, whether it's in the campus experience. I want to just throw out a couple of ideas for how a campus can respond to some of those challenges structurally, just as a kind of an initial salvo for some of the maybe concrete problem solving that we might be able to noodle over together. And then I'll turn it back to Mohammed and then David to respond to each other and then get our conversation going so we can open it out to you as well. So first, what I've I work at Georgetown Law. I'm the director for mission and ministry, meaning I also help to coordinate the campus ministry activities for the law school. It's a very large student population, about 2,500 students. And also a very varied student population. Our student groups are very strong with Jewish, Muslim, Dharmic Life, Christian Legal Society, Catholic students, all organized into very robust student groups. And so I think one of our questions in terms of managing the decisions about protests and speech and speakers was to make sure that as senior staff, also advising the dean and the associate deans, that we weren't working in silos. And so I think one question that we might ask ourselves is to think, in what ways are the parts of the university pulling against each other? So where there's a campus ministry not exactly in good communication with the Office of Equity and Inclusion or the Dean of Students. And so this sense of, I can't say we have exactly a team of rivals, but but we have, I think, enough of a team spirit with a variety of perspectives, and also being in touch with the on-the-ground experience of the different student groups at the same time, to be able to bring that into the decision-making about protests and speakers. And the other thing that I think is really important is to find a way to distinguish the specific people who are making disciplinary calls in a protest environment from those who are 24/7 doing the community building. Because you can just blow up your community building, David is nodding, right? You can blow up your community building capacities in one night, right, with a controversial call. So that's another just kind of question about structure and staff. The other question that I'd also like to pose to both David and Mohammed, I think one of the things we found useful in the wake of October 7th on our campus was to have a kind of flexible structure where we could distinguish the Zionists from the Jewish Law Students Association. And we have a very active Muslim Law Students Association, and then obviously the Law Students for Justice in Palestine organization is distinct, right? And so we heard this desire on the part of our own students that their spaces for community building, for spiritual support, for coming together across political differences within their own groups, not be swamped by the politics of the moment. And so I think this is another question for us. Is there something structurally that we can do, not to shut down the conversation within those groups, but to help the students themselves protect it from becoming swamped? And I think there's some structural fixes within how we think about student organizations that can help greatly. And then finally, just as a final note, we had the very good fortune of a few weeks before October 7th at the law school, having launched an interfaith advisory council with leaders from each of the 5 religious student groups, Jewish, Muslim, Dharmic, Christian, and Catholic groups. And it was set up with the idea of also getting out of our silos, finding ways to work together, improve communication with the school, and especially to give each other a heads up. And this, I think, goes to both some of what David and Mohammed were both saying, to give each other a heads up for events or speakers that might be sensitive or perceived as causing pain to another group. So when October 7th hit, we had in place a space where we were able to come together physically. Now, this, I believe, also raises really hard questions about scale, because I think so many of these spaces to foster a kind of from below fix, to respond to David's concerns, depend on not getting bigger than about 15. And so there was a particularly poignant meeting in November of 2023 where there was just an incredibly profound eyeball-to-eyeball recognition on the part of the Jewish students and the Muslim students. And it opened with something like, it is so difficult to have to start every conversation that I'm having with my classmates as, "Hi, I'm not a terrorist." And on the Jewish side, "Hi, I am not celebrating the death of children in Gaza." And so in that moment, because they were eyeball to eyeball, in person, in a small group, in a space that was not on a public platform, they were able to give themselves permission to recognize each other's pain, to see each other in a way that then they actually were able to give themselves permission to build deeper and more complex conversations among each other. And so I think another question would be, how do we cultivate these spaces where students can actually come together, see each other? And I don't think this is just a question of religious student groups. I mean, I think there's lots of division on campus around all kinds of questions. And so that might be just a few sort of practical ideas for how do we think about the above and below, above being in some ways what does the administration do in a university environment, below in terms of what's the kind of grassroots experience of students with each other, just a few kind of thoughts. But with that, let me first bring it back to Mohammed to respond to David or to some of these concrete ideas. And then David, your further thoughts, and then we'll just really throw it open to your questions and also the ways in which you might want to weave in some of your insights from the morning. So can I put you on the spot?
Sure.
Yep.
Amy, thanks so much. David, thanks so much. I really was looking forward to meeting you in person. And so I'm sorry you're not here with us. But thank you so much for participating by Zoom. And thank you for your generous comments. I do want to follow up on one point you raised about the difference between top-down censorship and bottom-up censorship through custom. And I think this is a particularly difficult question to think about. Because the university is different than the rest of society. So it may very well be the case that Jewish students, and I say Jewish students here pointedly because I think Jewish students are sort of by default what I would say cafeteria Zionists, or the way people talk about cafeteria Catholics, meaning that they're kind of socialized into Zionism, but don't necessarily buy into, doctrinaire political Zionism as articulated in normative documents of Zionism, or certainly the legislative structure of the Israeli state. At the same time, they might not know a lot about it either. And so I recognize that when they hear my sharp criticisms, and they are sharp, of the Israeli state, they experience that as a painful attack on their identity. I understand that. At the same time, I can't give too much weight to that, because what I see, and I've seen all my life since I've become a sentient human being, I literally have been engaging in Palestine advocacy since I was a tween, is that the Zionist movement has represented an existential threat to the existence of the Palestinian people. And I need to communicate that to my Jewish interlocutors, who I recognize on almost all range of values to share values with me. But for one reason or another, they seem to be blind to what the political project of Zionism has meant for the Palestinians. Now, that doesn't mean that Zionism has to be that way. It could change. But I don't know how to do that without ideological critique. And so you kind of have to build a grassroots movement, in my perspective, given the nature of politics in the United States and the overwhelming entrenchment of political support for Israel in the United States. So since 1946, according to the Center for Foreign Relations, Israel has received $310 billion of foreign aid from the United States, far and above what any other country has received. Israel, by the way, is a wealthy country. Its per capita income is $47,000 per person. Just since October 7th, it's received $20 billion in military assistance. Right? And so the only way in a democracy you can stop that is through a social coalition. So I would distinguish between creating a social coalition based on political principles of egalitarian politics and the kinds of customary sources of repression of free thought that Mill identified. That's sort of what I wanted to say. But it's very important for us, when I speak of us as like pro-Palestine advocates, I say Palestine, not Palestinian, because Palestine is the homeland for not just Arabs. Palestine is the homeland also for Jews who are in Palestine, Christians in Palestine, Muslims in Palestine. We need to say Palestine, right? I appreciate, efforts at Georgetown to bring Muslim students involved, but Palestinians, meaning the Arabs of Palestine, have to be explicitly recognized, and they have to be named, because anti-Palestinianism is distinct from Islamophobia. And there's a lot of what I would call Islamophobia washing, meaning that you pay lip service to being anti-Islamophobia in lieu of confronting what is happening and has happened to Palestinians since the end of World War I. Most people don't know this, but the peace settlement of World War I explicitly recognized Palestine as deserving of independence. The Covenant of the League of Nations recognized its independence as a part of the sacred trust of civilization. And here we are, over 100 years later, and Israel still doesn't recognize Palestine's existence. Palestinians are stateless. To be stateless means you don't have the right to have rights. And so this has to be said and identified as a particularly pernicious form of exclusion and marginalization. And if we can't say that because law is being manipulated to make that terrorist supporting, then we have a serious problem. Not just because of sort of larger philosophical issues, but it censors truth. You can go to the Covenant of League of Nations and read it. You don't have to trust Muhammad Fadl. You can see the Charter of the United Nations. There's no provision in the Charter of the Nations that permits the destruction of a mandated territory. Palestine was a defendant for the Permanent Court of International Justice in the interwar period. How could it be a defendant unless it was a state? These are not things I'm making up. These are not things that Palestine advocates are making up. This is part of the historical record. On the cusp of the partition plan, Arabs were 2/3 of the population of Palestine. At the end of the 1949 war, their population was dramatically reduced. It wasn't magic that caused that to happen. These are facts. What's going on today is an attempt to suppress facts and is diametrically opposed to what we should be doing in our universities. And we could be models for what could be if we are courageous enough to stand up for the principles of our universities and our law.
Thank you so much. David, do you want to jump in either on that or also kind of the broader weave with Mohammed's earlier remarks? Yeah, thanks.
Yeah. So one thing that I think is very important to stress, and I think is absolutely important, correct for Mohammed to underscore, is that we cannot conflate the tyranny of social custom with critical counter speech, right? In a university, in any part of public life, but especially in a university, people are going to make arguments that make you twitchy, right? That make us, that cut close to the bone. As you said, you have these very, very harsh critiques of Zionism, right? That's not a foul, right? In an academic setting, that the fact that someone throws a hard shot at an ideology or political practice that you identify with, the tied to a religious or ethnic or national identity, it's not a foul. It can't be a foul, right? It just cannot be, right? And that's got to be true with respect to, attacks on Zionism, right? I will say that what's good for the goose has to be good for the gander here, right? And so I think it's very frequently presented that claims of anti-Semitism, right, are not part of that conversation of that to and fro of figuring out the just, the right, the good, right, but something that stands outside of it, an attempt to thwart that conversation. I don't think it can be, right? The arguments can be malformed, they can be misinformed, they can be argued against the same as any other argument can be malformed, misinformed, argued against, right? But there isn't just as there isn't an entitlement of Jewish students, of anybody else, to be, free from hearing an anti-Zionist critique. There is not, I will say this, there is not an entitlement for even very passionate pro-Palestine protesters to be free from arguments that contend that, some things that they're making are anti-Semitic. They can argue against them, they can deny them, they can contest them. I would hope that in either context, both in engaging with the claims of anti-Semitism that I'm talking about now, what we would do and what we should do is listen with open-mindedness and fair consideration, which isn't the same thing as reflexive acceptance. I don't believe in what's sometimes said is to, just agree, say silent and agree. I don't agree with that, right? I don't think that that is a feasible way of doing political dialogue. But I do think that those virtues of open-minded consideration have to be considered important. And so one example here that I might bring up. I've worked for many years with NGO that's a representative of Middle Eastern and North African Jewry, often called Mizrahi Jews, often Sephardic Jews too, but mostly Mizrahi Jews. And this is, communities that approximately trace their origins to countries like Tunisia, Egypt, Iraq, Iran, Syria, and so on, Morocco. And I say approximately trace because virtually none of them are there anymore. And virtually none of them are there anymore because in the years kind of leading up to 1948 and then the years immediately following 1948, about 20 years after, virtually that entire community was decimated. In those countries, it more or less doesn't exist anymore. So it was about 900,000 Jews, and in those countries, that is probably a total of less than 5,000 now. They're all essentially in Israel or the United States or France would be the other major location that they live in. And that program of of dispossession, of expulsion, often for many years, in many situations at least temporarily statelessness, was carried out. We talk about uncomfortable thoughts. It was carried out under an anti-Zionist banner, right? Does that mean anti-Zionism has to be that, as you say? No, it absolutely does not, right? But we talk about, what it means to reckon with history, right? Well, that's part of the history we need to reckon with too, right? And so when we talk about, these things being felt as existential threats, when we look back over history, I talk to my friends in those communities, right? And the reaction, it's, I don't think it's quite fair to them to say it's a socialization into cafeteria Zionism, and that's why, that's why they feel, kind of picky, right? It's more that, just as for Palestinians in the Gaza Strip right now, or in a refugee camp, dating from past 48, the, salient, impactful, concrete element of what Zionism is that form of dispossession, right? Remember, these communities, the salient, concrete, material impact of what anti-Zionism was, was something very similar, was being expelled from their homes, was being deprived of rights and being denied full and equal membership in a political community. Now, I think what we can say, that those things, when people, I always hesitate to raise that because it feels that in 90% of cases when people do it, it turns into this dueling whataboutism, right? Well, I'm not hurting, you're not hurting, I'm hurting, right? This way of downplaying or whatabouting vulnerabilities, real vulnerabilities felt by others. And I hate that it does that, because I think it should be doing the opposite. The broad point that we should be coalescing around here is that these are commonalities, they're not distinctions, right? Right? When we go back to that University of Washington survey, right? The broad point is that all of these communities, Jews, Israelis, Arabs, Muslims, Palestinians, feel vulnerable, right? There's a shared sense of anxiety. There is a shared sense of vulnerability. If I can be very blunt, there is a shared realization that if one's loved ones are killed, a non-trivial portion of the people you thought were part of your community will justify, if not cheer the deaths, right? Whether it's cheering them as terrorists or cheering the deaths as colonizers, right? And that shared sense of alienation, right, can be the foundation of something different and something better, right? But there has to be the willingness to share. They're not selling anybody out by acknowledging these shared vulnerabilities, that they're real, that they're not invented, that they're not, just moments of too much sensitivity. And I think this will circle back to what you were saying, Amy. I think that once we acknowledge that, that's how you can start scaling up, at least a little bit, the sorts of structural mechanisms for facilitating conversation that are so desperately needed. Because what's needed in those contexts, my non-Rawlsian hat here. I like Rawls, but I wouldn't necessarily identify as a Rawlsian. It's not, it's not really, I think, a framework of rights and entitlements and the First Amendment and any of that, right? It's sets of virtues and social conditions like trust, right? Empathy, these oftentimes softer virtues, right, that can't be encoded into formal rules, right? Because I don't know, I've tried, I can't figure out a formal rule that distinguishes harsh counterspeech, obviously okay, with, sneering dismissiveness, unwillingness to listen, definitely not, right? I can't come up with a rule that tells us why it's obviously okay to no platform the person who's a Holocaust denier, right? But, we shouldn't be doing the same thing when it comes to, just workaday Zionist or anti-Zionist speech, right? It's deliberative ethics, right? It's matters of right? And I think it has to come from places of fundamental belief that both you and your counterparty are part of a shared project where you care about the other. Not necessarily having full agreement, often having very profound disagreements, right? And disagreements that can be expressed in, in no uncertain terms, right? But
David, I think we're gonna go to questions, but I wanted to just highlight right now that you just gave an enormous plug to the University of St. Thomas Law School. In the sense that the highlighting that the kind of work that we need to do, I believe, in this place of forming lawyers, to asking what is the stance that gives us the imagination to kind of hold these kinds of conflicts. And so maybe this sense that it's not like we're looking for conflict resolution, but I'm going to use a phrase from my friend Bob Bordone's new book called Conflict Resilience. That the challenge is not so much to find a kind of neat answer to every question, but to develop, you could call it the virtues, the capacities, the practices, as professionals to be able to lean into these really hard spaces where there may not be clear answers how we hold these kinds of tensions. And I think that's a large part of the work of kind of forming lawyers and forming the moral imagination that will help you be excellent professionals. Now, I also wanted to thank both of you for modeling, I think, what we hope to hold in terms of no easy answers and no easy ways to hold both, but the sense that we do have to find an imaginative capacity to bring them together. So now is the hard part, which is to turn it to you to for your thoughtful questions. I realize this is like drinking from a fire hose in terms of the depth and the breadth of the not just of the content and of the ideas, but I think of the challenges that both of these scholars and teachers that I so respect and have learned so much from are holding in their own work. So is there a microphone moving around? Yes, or even just comments, that might be coming to mind at this point. And again, feel free to weave in thoughts from this morning too, because I think there's interesting.
Thank you for another really great panel. I wanted to address something that David said at the end and something you just referred to, Amy, and then solicit thoughts from either Mohammed or David on it. So David, you referred to this, the importance of the stake that participants in the conflict on campus have in one another, ethic of care of sorts, and Amy, you referred to a similar, I think, commitment. But we know that the Age of Enlightenment, as articulated by people like Kant, for example, deeply tied to Rawls, right, is about regarding another person basically as someone you can never use for your own end. And that's rooted in a pietist background that Kant inherits from his family. This is a deeply Christian notion tied to a universal kingdom of ends. When we come to Rawls, he tries to predicate, initially in justice and fairness, a notion of equal regard in a hypothetical arrangement. But then he moves away from that. He goes to political liberalism. I don't want to get too distracted by that. So just coming to our contemporary period, we can look at the absence of an ethic rooted in the kind of eschatological vision that Kant secularizes, that Martin Luther King explicitly articulates in the civil rights movement, as rooted in Christian commitments, where he's not seeking merely to win a political victory, but to redeem white America from the disease of sin and to save individual souls. So for him, the historical victory is relativized in light of an eschatological vision of universal salvation. Where is that kind of commitment available? Because I don't frankly see the possibility of it, absent a transcendent sense of a kingdom of ends that would persuade a person to sacrifice the here and now eminent victory on behalf of a care and concern for someone that is not a part of their tribe and their community. The Christian vision has the idea that all people are ultimately a part of a common human family. That may be true of the Jewish and the Muslim faiths as well. I'm just not going to comment on that because that's not my expertise. But that's clearly present within that tradition. The tradition is every human being, whether Christian or not, is sacred, created in the image of God, and therefore entitled to a certain kind of treatment, however short Christians have fallen of that. We can at least point to those resources. We're in a secular context. Why would we embrace that? Why wouldn't we just insist that if we can win now, and we can vanquish the other side, we should do so? I'm not, of course, defending that view, but that's a common sense view that many people throughout history have pursued. Go to the Roman Empire, and this is Tom Holland's book that Joyce pointed to earlier, and the transformation that Christianity meant for the Roman world. In that era, I think Nietzsche is right, although talking in a different context, that there's a difference between a slave morality and a master morality, and the Romans certainly did not celebrate the virtues of weakness. They did not celebrate that.
So, Mohammed, I don't know if you want to jump in on that. Yeah, go ahead.
Those are really big questions, and I don't want to get into sort of Islamic theology and kingdom of ends, although, I've actually written a paper on contrasting Islamic conceptions of sacrifice with biblical conceptions of sacrifice, Jewish and Christian, and why I think the Islamic conception is interesting, particularly from the perspective of liberalism. I'm happy to share it with you offline. I think one of the weaknesses with Rawls, and as I say in that paper, is he gives no account for why we should be reasonable, right? He assumes that all human beings have the capacity to be reasonable, are prepared to offer fair terms of cooperation to others, and he assumes this is easy for people. But it turns out, I think, it's really hard for the things that you just said, right? And I think the tragedy of Zionism is that, and I say tragedy, intentionally, because in many ways I'm very sympathetic to Zionism, because Jews, just like my people, were colonized, maybe internally colonized in Europe, but still colonized in the sense of not being fully equals, and Zionism was an attempt to solve this problem. So I'm not unsympathetic to Zionist aims. My main criticism is how that is being pursued. But Herzl completely internalized the politics of the 19th century of the survival of the fittest and social Darwinism of the era. And in his Jewish state, he says the basic problem is one of international relations. And international relations, might makes right? And then within a state, the majority at any moment in time can make a minority a stranger. So if that is the reality of the world, which basically you just said, why not just vanquish your foes if you have the time? Then of course the only source of security is a state in which you can never be turned into a stranger, right? Now it happens to be my belief, maybe it's naive, that we learned that that point of view leads to the destruction of everyone, because everyone is going to try to defeat the other, and you end up with world war, right? And so the solution is what we were trying to build in the post-World War II era. Now, of course, Trump is systematically demolishing it. When he pursues Make America Great Again, well, everybody wants to be great again, right? And that'll eventually lead again to global conflict, right? So Rawls sort of assumes this capacity for reasonableness, and I think he takes for granted that different comprehensive traditions have the resources to produce subjects that will be reasonable. But it's not clear to me that the institutions of political liberalism as they exist have been successful in producing those subjectivities. That's why we're in the crisis we are in today, right? And that's a big problem for somebody who advocates a kind of political liberalism like myself. How do we produce reasonable citizens? It doesn't seem easy.
I'll just throw in here also, I think Pope Francis has a lot to say with his reflections on the culture of encounter. And why I'm so drawn to that is the way that the stakes are framed, in that I don't reach out with curiosity and deep appreciation of the other made in the image and likeness of God, only for that person, but also for myself. That my own identity as a human being is tied up with the capacity to open myself to relationships of love and appreciation. And so this sense that it's baked into my identity. I think Dr. King has a reflection on the Good Samaritan and this sense of, if I'm not like completely taken by what will happen to that Samaritan on the road if I walk by, I'm less than human. And at a certain point he says, what will happen to him? And I think the question is also, what will happen to me if I walk by, because of the way in which I deny my humanity? And so I think the ways in which, this came to me in the earlier panel as well, reflecting, how do we translate these deep theological convictions into ways of being socially and on the ground, right? Sustaining these kinds of relationships. David, we've got just a couple more minutes. I want to let you jump in here, or also if there's other things that you want to tie up in your comments.
Yeah. So it called to mind the famous Disraeli quip about how, the Jews are a nervous people because centuries of Christian love have frayed our nerves, right? So I mentioned that, I appreciate roles. I identify as a pragmatist, right? In both the colloquial sense, but also in the Dewey Rorty sense, right? More specifically than. So when I hear people say, well, we need this foundation that makes it so we, care about the other. We care, we have a reason, not to just pursue our own, our own interests above all else, to just go for domination. Really, and my instinct is like, do we need the foundation, right? Why can't we just do it? Right? It seems perfectly attractive to me. And if the most brilliant philosopher in this room managed to prove beyond a shadow of a doubt that there was no foundational reason, no rule of the universe anywhere that said I had to, care about other people beside myself, that the universe was completely agnostic, do whatever you want. It wouldn't change my behavior at all. I wouldn't be like, oh, well, thanks for the moral license. I'm going to go torture a kitty, right? I wouldn't change anything. So I've always actually been profoundly skeptical of the need for that, partially because I just don't find the alternative that attractive. I, look at the world you were describing, Muhammad, of war of all against all, very Hobbesian, just pure domination, doesn't sound very nice to me, right? And so telling me that that's an option in front of you, if you don't have these foundational approaches, that's an option that I don't want to pick, right? Is where I end up coming down on that. And so I think more broadly, right, we see, and we've certainly seen this, I think in certain manifestations of Christian practice over the centuries, the promises and the perils of over-universalization, right? That there are ways that being too demanding of, we're all part of this singular kingdom, right? Under God certainly can be a leverage point for benefits, but it very much can be a point for oppression as well. Same thing for the hyper-particularism, right? That can be a leverage for certain benefits and claims that are very important, right? There's a reason why Algeria's decolonization movement was very much not about just being equal citizens within a broader French state. It was about particularization, right? And I think that is entirely sensible. And we see those sorts of claims made around the world, in Quebec and in the Basque and in the former Yugoslavia, right? And we see in all those situations the benefits and the risks of both the universalization approach and in the particularism approach. So I tend to view us as needing, again, a good dose of colloquial pragmatism in terms of how we approach this, rather than looking for this, perfect Rawlsian Christian, whatever you want it, otherwise foundation that can, prove to us that we need to behave in exactly the right way. I don't find it feasible. I think it ends up leading usually to some dangerous places, and I just don't think it's necessary.
Can I just say one thing?
Yeah, 30 seconds.
30 seconds.
Okay.
Yeah, I agree with much of what you say, right? However, I would not call it Christian universalization, because this is not, I'm going to do a little sectarian push here. I think that Christian universalization is mediated through the church, which the church is a very particularistic institution. So I would contrast Islamic universalism from Christian universalism, because Islam grounds its universalism in natural religion that doesn't require a church. And it assumes that the virtues of natural religion are, by definition, natural to all human beings. And I think that provides a sounder basis for a universal system of justice than something that's mediated through the particular institution of a church or a people.
So I think we've
I'll say one more thing quickly. We've heard the virtues of the Christian approach.
20 seconds, David.
I have a fondness, perhaps, for the more distributed, pluralistic approach of Talmudic Judaism, which is highly particularized, allows for pluralisms, allows for differentiation. It never does try to differentiate or to universalize itself. These and these are the words of the living God, in the words of Hillel, which I've always found another way of thinking about this. And it's wonderful to have some, see the different approaches of the major religions in thinking and how it can apply to contemporary political theory.
So with that, I think we have reached our goal, the same feeling I had at the end of our Zoom to prepare for this, that we would need 3 weeks to to fully flesh out the ideas and the sparks of new directions for how to think about these really challenging questions. So I think if you could join me in thanking David and Mohammed for all that they've brought to this conversation. And to be continued. I know my desire was to run out and dip into their scholarship, because I think there's just so much to work with. So thank you to all of you. Thank you so much.
So as you're finding your seats, once again, I want to welcome to the stage our panelists and to the screen. There we go, look at that. Our panelists for this final panel today. Some brief bios on each of them, and again, as I've said before, you'll be able to find more about their phenomenal backgrounds in the pamphlet that you picked up on your way in this morning. We'll start first with Professor Andrew Lewis, who is an associate professor in the School of Public and International Affairs and the executive director of the Portman Center for Policy Solutions at the University of Cincinnati. He holds a PhD in political science from American University and currently serves as the co-editor-in-chief of the Political Science Journal of Politics and Religion. Next up, we have Professor Logan Strother. Logan Strother is an associate professor of political science at Purdue University. He earned his PhD at Syracuse University's Maxwell School of Citizenship and Public Affairs in 2017. He is the co-founder and co-director of the Program on American Institutional Renewal, a center at Purdue that fosters research and teaching of America's governing institutions and works to build links between academics and practitioners who are working to improve the functioning of our government. On the screen joining us, and I'd be remiss if I did not give her a special welcome, our co-host and co-planner for this event, Professor Asma Udin, who's a professor, author, and lawyer specializing in religious liberty. Her recent major publications include When Islam is Not a Religion, The Politics of Vulnerability, and multiple scholarly articles utilizing social science theories to map depolarization strategies for the U.S. Supreme Court. She has also held fellowships at Harvard, Georgetown, UCLA, and most notably right here at the University of St. Thomas. And last and certainly not least, who many of us in the room are well aware of, Professor Gregory Sisk, seated on the far end, who holds the Langai Distinguished Chair in Law at the University of St. Thomas. Professor Sisk has published more than 6 articles on professional responsibility, litigation with the federal government, and judicial decision-making. With his co-author, Michael Heese of Cornell Law School, Sisk's ongoing empirical studies of religious liberty decisions in the federal courts across several decades have been published in the University of Chicago Law Review, the Iowa Law Review, the Michigan Law Review, the Northwestern University Law Review, and the Notre Dame Law Review, among others. So without any further ado, I will turn it over to you, Professor Sisk.
Thank you. Actually, I am the least today. I'm just here to moderate, and that's a very easy thing to do because we've got 3 wonderful presentations, and so that will prompt a number of very interesting questions. So each of our 3 contributors will speak for 7 to 10 minutes, and I know at least one of them, yes, has PowerPoint slides, which are already up. We will take them in the order that they were introduced to you, so Professor Lewis.
I'm going to stand up since it's the end of the long day, and mostly for my own sake to get the blood flow moving. But I just want to say it's a pleasure to be here. I want to thank Tom and Asma for helping put this together, and Mason for the generous remarks and organization of all of us. I'm not a lawyer. but I'm glad to be here and talk a little bit about the law. What I try to do is think about how the law and the public intersect. And so we're going to do that a bit today, talking to you about some work I do on the sort of the politics of religious freedom and religious liberty. And I think it harkens back especially to the first panel of the day. And so I'm going to see if I can hit the right button. Maybe not. Try now. Oh, down button. There we go. As Professor Berg notes, that we live in a polarized age, for sure, but I think even more than that, we have a polarized or polarizing conception of religious freedom and religious liberty. And especially over the past 10 to 15 years, we see religious freedom become politicized, and I would say polarized in many respects, right? So not only becoming part of the political context, but sort of dividing and extreme view taking. And we see that among elites, advocates, lawyers, public commentators, the weaponization discussion of religious liberty. And then we see that in public opinion too, how the public understands these issues, how they interpret them. And so one of the things that I have done in my work is try to intersect the role of the courts and the law and the Constitution with the public and the public's views and perceptions. And so I have a sort of a long-standing research agenda on the public's conceptions of religious freedom and how that works. And part of what I want to do is try to understand where there are real divides, okay, where is there potential polarization, division, different conceptions, and where might there be common ground? And where can we find ways where people can agree on things like principles and avenues and understandings? And are there mechanisms to help us reduce this type of constitutional polarization? And so I think that's the harder thing. I'm going to end with a bit of that today. So again, I'm going to try to give you a little bit, and I think a bunch of this is going to come out in the Q&A, but I would say there's generally pretty broad support for I would say like basic principles about religious freedom and even free expression and broader First Amendment questions that we have all been thinking about today. In the abstract, people are generally quite supportive. And there are differences where, Republicans will rate religious freedom more highly than Democrats, for example, or they might think that is a more valued right. But the differences aren't huge. And I think there's some broad scale agreement. But when we get down to some specific application points, and then also I would say the perceptions of the status of certain rights, then we start to get more and more polarized views. So one of the key things actually is about how threatened is religious freedom in the United States, right? There is a real polarizing viewpoint on the status of that right. How not only how important it is, but how under threat it is and who is threatening it, I think are some of the key questions. And then there's all kinds of questions about, whoa, hit the wrong button. All kinds of questions about, who should win in certain cases, right? Who's more likely to benefit? And I would say there's clear evidence that we interpret our understanding, and this is where I think some of Logan's work gets into this in different facets, but we interpret our understanding of the court and of these outcomes based on partisan shortcuts. In fact, I've got some work where you take the exact same religious freedom message, you just switch what the party is of the person who's explaining that to you. Same message, different party, and people have wildly different conceptions of if they think that's right or wrong, right? Good or bad, positive or negative. And so we're filtering these cues often through partisan shortcuts. And often it also matters who we think is going to benefit. Is a group we like more likely to benefit from this ruling, or a group that we don't necessarily like? And those are affecting sort of how the public views these things. And so partisanship, polarization, especially this sort of affective group-based polarization that we heard about over in the lunchtime, these kind of things can matter for us. Now, one of the things that I've been working on, and Osman and I actually have done this a bit together, is can you combat some of these polarized outcomes? Are there messages, techniques, approaches that might be possible? Are there messengers who can help support, especially what I want to think about, religious freedom support for everyone, for all types of groups, right? Sort of an inclusive, broad religious freedom that many of us were thinking about today. And so one of the ways I have done this over the past few years is to engage in what we think of as in social sciences survey experiments. And so this you take a survey and you randomize the types of messages they get, and then we can compare the outcomes on these different messages and see, like, oh, are some of them more effective than others? And one of the avenues that Osman and I have worked on is sort of, can you help evangelical Christians to be more supportive of Muslims' religious freedom rights? And so I'll just tell you a little bit briefly about some of those things, and I think they'll come out in the Q&A. But we fielded a pretty extensive survey, I guess in 2023, that this national survey, 4,000 adults by a pretty prominent survey firm, and we tested some different mechanisms for how people would think about religious freedom and how you might promote a more inclusive version. One is to express solidarity with a group, say like, hey, we really care about your religious freedom, we know that matters, so you should also think about somebody else's too. And so we presented them some vignettes and some news stories using that approach and using different messengers and different messages. We tried to do some correction of errors and say like, hey, I know sometimes people perceive this, but the reality is it's more like this, right? So we did that with the case of like Sharia law. We also did it with some stuff that had to do with religious liberty exemption cases that were dealing with, particularly with Christians. We talked about threat, and then, some people try to elevate the threats that are at play in society, especially around religious freedom, religious conflict. And so we increased the threats, and then we also tried to tamp them down and try to see how people reacted. And I won't go through it all with you today, because we'll do it, I think, some of it in the Q&A, but I'll just say, like, the big takeaway from some of my work is that both the message and the messenger seems to matter. And I would say also, perhaps more importantly, some of these psychological factors, so sort of how you think about groups, how you appeal to people, can matter more than simple error correction. So we didn't get a lot of effect on error correction, but more impact on things like expressing solidarity with one group and saying, hey, I understand your concerns and these matter, and then let's take those and apply it to somewhere else. So that sort of solidarity was helpful. So for example, in one of our groups, we had people expressing solidarity with a group of evangelical Christians and then asking them to support Muslims' religious freedom claims. We found that if you engage in those solidarity messages, that everyone ended up having more support for the Muslim religious freedom messages. Okay, that those solidarity claims compared to non-solidarity claims yielded more support. And so it was sort of buying some sort of credibility. Now on the other side, if you had conservatives ramping up the threats to religious freedom, then Republicans were less likely to support Muslims' religious freedom rights. That in some ways it was exacerbating the group-based differences, my team and your team sorts of things. But if you calmed those religious freedom claims, saying, hey, listen, things are generally protected, there's some stuff we need to work on, but we should not, the threat isn't as big as we often think, that actually closed the gap between the differences among groups. So like, Republicans are more likely to say they view evangelicals positively and Muslims not quite as positively, right? But that gap would be closed if the tension was not escalated, if it was calmed a little bit. And then the messengers also matter too, and I think particularly you want to have trusted messengers. All right, and I think that's one of the main things that we found, especially for people who are a little skeptical. And so we found things like solidarity messages that were being delivered by a Christian leader were more likely to get support for Republicans. So they were more likely to care about those types of messages. So that you should think about the messenger. All of this to me, I hope is insight for how people, advocates, lawyers, commentators, bridge builders want to think about the role of religious freedom. And we can talk more about all these sorts of projects later, but I'm going to pass it along to my colleague Logan. It's a down button, yes. Okay.
Do I have slides?
I think we're working on it.
Okay. Well, while he's working on my slides, I'll introduce myself. I'm Logan Strother. I'm a political scientist. Also not a lawyer, though I do co-author with a lawyer. My co-author in this paper is a law professor, Ben Johnson. I want to echo Andy's thanks before I get started to everybody who put this together. It's been a great slate of presentations today, and I'm happy to be a part of it. So I've spent the last decade or so thinking about the relationships between the Supreme Court and the mass public generally. And so about half of my research agenda thinks about, about half of my research agenda thinks about whether, under what conditions, how the Supreme Court influences public opinion. And the other half of my agenda, more or less, thinks about whether, how the public influences the court. What I'm going to present today is in the latter vein, though I'm realizing in listening to all the presentations today that maybe something from the first half of my agenda would have been a bit of a better fit. But I'm going to try to square the circle in the presentation. So there's growing concern today that the Supreme Court in particular is out of step with the American people. And this is raising legitimate concerns, like well-founded concerns about the Supreme Court's legitimacy as a sort of authoritative, neutral decider in our politics. The court's unpopular decisions, whether this is like broadly unpopular decisions or polarizing decisions, right? Decisions that maybe 30% of the public loves and 30% hate, do polarize, right? They have polarizing effects on the public. And this is in part because the public generally updates its views about the court and about politics based on sort of agreement with court decisions, right? So if the court issues a decision that you like, then you say, the court's doing a good job. And if the court issues a decision you don't like, you say, it's doing a bad job, right? So unpopular decisions are actually polarizing. I'm not going to show you that today. This is sort of a finding from the other strand of my research. And what I'm going to show you today takes that for granted and considers the sort of implication of this finding. So there's a big literature in political science and economics. A number of law professors have worked in this area as well, like Ted Brugger and Barry Friedman. They've argued that we shouldn't worry too much about these polarizing cases because the Supreme Court doesn't stay out of step with the public for very long. For one reason or another, the court responds to public preferences, and this would, my other work shows, have in the long run sort of depolarizing effects. Right? So what I'm going to look at in this presentation today is whether the Supreme Court does in fact respond to public opinion in civil liberties cases. And I'm going to zoom in on the First Amendment even more specifically. I can't drill down to like religious freedom that specifically for methodological reasons I'm happy to talk about. Right? I'm also not going to talk about the approach in the interest of time, but very briefly, the approach I'm going to take here is I'm going to look at Supreme Court outputs on the one hand, and I'm going to look at public preferences about civil liberties issues, about First Amendment issues specifically on the other hand, and see whether there is a systematic relationship among these things, either over time or in a more contemporaneous way that we might think of as potentially indicative of a cause-effect sort of relationship. Okay? This literature that I referred to that says the court responds would have us expect that we should see that changes in public preferences reliably lead to changes in Supreme Court outputs. And based on whether you think the court responds sort of directly by like justices considering what the public wants and sort of going along with that sometimes, or if this works more indirectly through the process of personnel change or through like sincere attitude change among sitting justices, right? Like over time, changing your mind about the death penalty or about free speech or something like that. These would manifest in different ways, which is why I look at this in two different ways. I'm not going to show you any statistical models or anything like that because I think a couple of pictures tell the story pretty well. So what you see on the screen here is just two series. The dashed line is
we'll say the liberalism of Supreme Court outputs. On the x-axis, you have time, so this is like at the term level here because it's easiest to visualize in that way. You can think of this essentially as the proportion of the court's decisions in a given term that come out in the liberal direction. And then the black solid line is the public's liberalism on civil liberties issues particularly. I'm happy to answer questions about measurement, but essentially we just like extract the latent liberalism from like hundreds of survey questions at the level of the year. Okay. What this figure is communicating is that there's really not much relationship between these things, right? The court bounces around quite a bit. If anything, the public is much more stable in its preferences, and there's been, over the last 60 years, a long, slow, steady decline in public liberalism on civil liberties generally. This picture is even starker in demonstrating the sort of absence of any sort of relationship between the time trends here. This is the series focusing on First Amendment issues. So again, the dashed line is a Supreme Court liberalism in First Amendment cases, and the black solid line is public preferences on First Amendment issues. Okay. So the public has not moved very much at all. Notice that the tailing off of like expression attitudes after 2016 among the public. The court dances all over the place. The public doesn't move very much. Right? So you don't need a lot of fancy math to appreciate that there's not much relationship between these two series. Okay? I did do fancy math anyway because that's what I am paid to do. I'm not going to, again, show you any of that, but the upshot of the analyses is that there's really no meaningful relationship that would indicate any sort of indirect relationship between the court and the public. And if anything, there seems to be evidence that when the when the public is relatively more liberal, the court is more conservative, and vice versa, right? So the court seems to be consistently over 60 years sort of out of step with the public on these issues. Okay. So the upshot of this for our purposes here is, like, one, there's really no good evidence that I can find that the court responds in these issues. And that means that the court is not, I don't think there's any good reason to expect that the court is going to be a depolarizing force in our politics, right? If a goal of ours is to sort of depolarize, we need to look other places, right? The court's not going to be able to do that work for us. Maybe this is a good thing, as I'll say, like the one bit of, normative content I'll inject here is if you think the role of the Supreme Court is to be a neutral decider, then maybe this is good. You don't want a court that sort of follows the public. But if you think of the Supreme Court as more tiny unelected legislature making national policy for everyone, maybe this is more of a normative problem. And I'll leave it at that. Thank you.
Asma, you are up.
Thank you. Mason, Professor Berg, and I have been working on this conference for months, and it's been exciting for me to sort of watch it all come together. Many thanks to the speakers, the moderators, the audience for being there and for making it possible. So Andy and Logan aren't lawyers, and I'm not a social scientist, but I'm always fascinated by what social science teaches us about the law, including most recently what it tells us about how the Supreme Court writes its opinions and how that language shapes public trust. So we usually think of the Supreme Court as resolving legal disputes, but in identity charge cases, its opinions do more than announce a rule, right? They help shape how people feel, whether they feel seen, heard, and protected under the Constitution. In that sense, the court doesn't just define the law, it helps define who belongs in our constitutional community. And that's why rhetoric matters. In a time of depolarization and declining trust in institutions, the way the court speaks can either reinforce exclusion and division, or it can foster legitimacy by making more Americans feel included in the constitutional project. And I think social science helps explain this, right? So you have Tom Tyler and his research on procedural justice, which shows that people are more likely to accept decisions, even the ones that they oppose, if they feel the court listened, respected them, and treated both sides fairly. Dan Kahan's theory of cultural cognition adds that people evaluate rulings through the lens of their identity. If a decision seems to affirm their values, it feels legitimate. If it doesn't, they dismiss it as biased. And more recently, Dan Simon and Nicholas Skerrick found that when judicial opinions include respectful engagement with both sides' arguments, even when the outcome is controversial, people view those opinions as more legitimate, more procedurally fair, and even more legally correct. In other words, rhetorical inclusivity shapes how people assess the law itself. So it's not just about who wins, it's about how the court speaks and whether the language affirms people's moral commitments. So I propose 4 strategies, and this is pulled from the social science literature, and I kind of weave it together. And these are strategies for how the court can write more inclusive, legitimacy-building opinions. The first one is self-affirmation, which involves acknowledging something positive about the losing side. When people feel attacked, they react defensively, but when their values are first affirmed, they're more open to disagreement. We see something like this in Obergefell v. Hodges, where Justice Kennedy's opinion affirmed the dignity of same-sex couples by recognizing a constitutional right to marry, but also acknowledges that many Americans same-sex marriage based on quote-unquote decent and honorable religious beliefs. That rhetorical choice didn't change the legal outcome, but it mattered. It sent a signal that religious objectors weren't being cast as bigots or excluded from the constitutional community. And yes, there was backlash after Obergefell, but over time, Kennedy's framing helped to build a foundation for mutual recognition. By 2022, we saw bipartisan support for the Respect for Marriage Act, which codified same-sex marriage protections while also including explicit safeguards for religious institutions. So that's what self-affirmation looks like in judicial rhetoric, acknowledging the moral worth of both sides, even a decisive ruling. It's not about softening the law, it's about writing in a way that leaves space for inclusion and belonging. So the second strategy is expressive overdetermination, which involves embedding multiple moral or identity-based signals so that different communities can see their values acknowledged, even, again, when the decision comes out in a way that makes them the loser. In Masterpiece Cake Shop, which involved a Christian baker who declined to make a custom wedding cake for a same-sex couple, the court didn't issue a broad ruling on free speech or religious exemptions. Instead, it emphasized that Colorado officials had shown hostility toward the baker's religious beliefs. But beyond the legal reasoning, the opinion's tone and structure left room for both sides to see something of their values. For supporters of religious liberty, the court affirmed that the government must treat religious convictions with respect. And for supporters of LGBTQ rights, the decision was limited and left future protections intact. The court didn't mock or vilify either side. Instead, it used language that signaled the legitimacy of the moral concerns on both fronts. Contrast that with Kennedy v. Bremerton, which is a case that involved a high school football coach who prayed at midfield after games, often in view of students. The school district worried that this created pressure on the students to participate, but the majority opinion treated the case as a straightforward religious liberty issue, barely acknowledging the coercion concern. The dissent, meanwhile, focused on coercion without recognizing the coach's genuine religious expression. A better opinion would have rhetorically affirmed both sides. The teachers don't lose their religious rights, and the students deserve protection from subtle religious pressure. That's expressive overdetermination, using rhetorical structure to honor both sides' values while still reaching a definitive and clear legal outcome. The third strategy is apparetic reasoning. Apparetic reasoning is judicial humility, which it means acknowledging that the issue before the court is really hard and that there are strong arguments on both sides. People are more likely to accept rulings they disagree with when the court shows that it understands the stakes and respects competing views. So 303 Creative v. Ellenis, which is a case that could have benefited from this, it involved a Christian web designer who didn't want to create same-sex wedding websites. The majority treated it as a straightforward free speech case and barely addressed LGBTQ dignity and inclusion. And that was a missed opportunity. The court could have affirmed both the designer's right not to speak and the moral weight of anti-discrimination protections, signaling that this wasn't an easy case and that both sets of values matter. And the fourth strategy is engaging the full moral spectrum. So Jonathan Haidt's moral foundations theory shows that liberals and conservatives rely on different moral values. Liberals emphasize harm and fairness. Conservatives also value loyalty, authority, and sanctity. Court opinions that speak only in liberal or conservative moral language risk alienating half the country. Take Roman Catholic Diocese v. Cuomo. During the pandemic, New York capped attendance at houses of worship, while allowing other businesses more flexibility. The court struck down the restrictions, but the majority didn't seriously engage in the state's public health rationale. In other words, the opinion focused on liberty and tradition, but largely ignored harm and care. And the ruling felt to many like a political victory for one group rather than a thoughtful constitutional balance. So in conclusion, the court doesn't need to compromise its rulings, but it can write in ways that affirm identity, acknowledge complexity, and speak to a broad range of moral values. In short, judicial rhetoric can model the kind of constitutional discourse our democracy needs. Thank you. I look forward to the conversation.
For this next part, I'll come to the podium as well. I appreciate very much Mason introducing me as last but not least, but I truly am least today, and thankful for it. You noticed how wonderful a job I did moderating the panel. They were all so disciplined because they were fearful of what I would do if they went over their time, that not a single one did. And now I'm going to ask a series of brilliant questions for which I can take no credit because they shared suggestions for those questions with me, and I have them right here in front of me. They are brilliant questions that I think will greatly help advance our discussion. So for the next half hour, what we're going to do is have me ask various questions of the panelists, and they will develop further the thoughts that they've already shared with you. And then around 4 o'clock or so, we'll turn it over to questions from the audience. So let me take them in the order in which the panelists contributed. So. Lewis, Professor Lewis, let me ask you about the source of polarization. Is polarization greater among religious lines or partisan lines? And then as part of the difficulty of that question, can you separate the two?
That's a good question.
Thank you.
I would say certainly they're mixed, right? It's impossible to fully separate people's overlapping identities. In the survey data that I've been looking at, and I'm talking numerous surveys over a series of years over the last decade or so, it seems to be that like the greatest level of what we might think of as polarization, so differences, right, and exacerbated differences of views is primarily through partisan lenses instead of through religious lenses. Now, that comes with one really big caveat, is that it's quite difficult to get good samples of smaller religious groups, and then sometimes when you get those good samples, they don't have the kinds of questions you would have wanted to ask them. And so, but it does seem that like the politics, right, the partisanship is the biggest driver of these differences. For example, I do a lot of comparison of evangelical and white evangelical Christians and Republicans. Now, there's a huge overlap, right? I think in some exit poll data, you'll get 81% or something of evangelicals would support a Republican candidate for president. And so there's a lot of overlap. But when you look at particular questions about religious freedom, the Republicans have more movement. Republican identity has more movement attached to it than evangelical Christian identity, right? So in a multivariate statistical models, it's the Republicanism, all things considered, that seems to stand out. And so I would say our politics perhaps have taken on this greater force in this sort of religious freedom conflict, that where maybe in the religious wars of the 15th, 16th, 17th centuries that we talked about earlier, it would have been a little bit different. Though perhaps maybe there were politics there too that they were assigning to their religious labels and identities, and that this is sort of part of how we interpret things.
I want to ask a couple of follow-up questions, Professor Lewis, before we move on. In terms of polarization among either religious groups or on the partisan side, is it evenly distributed, or are there outlier groups, left, right, religious groups that are more polarized than others?
Yeah, so I would say like it depends on what kind of polarization we're talking about. Republicans are more likely to be to have stronger views on, I would say, the salience of religious freedom, and particularly the threatened nature. So, for example, I ran there was a big national survey that was done by the Knight Foundation a few years ago that I was a part of. And one of those questions we asked people about how threatened they thought freedom of religious expression was and how important it was. And almost every group, whether it's religious or political, thought that religious freedom was more important than threatened, except for one, and that was the Republicans. Republicans are more likely to say religious freedom is more threatened than it is important. So their level of threat was quite high. But when you get to actual issues about religious freedom, we also asked a battery of questions about, do you support religious freedom, health exemptions related to COVID? What about some of the same-sex marriage cases? What about religious minority groups, including Native Americans, Muslims, and Hindus, in some different scenarios? And there was general stability among evangelical Christians, and Republicans moved a little bit, but not enormously. But the biggest, I would say, polarizing moves were among Democrats or the non-religious. That they were really low on what you might think of as traditional or conservative Christian religious freedom claims, and then they would become much more supportive of minority claims. And so on the issues, I would say the Democrats or the liberals moved more, but then on the feelings, right, the threat feelings and the effective views of religious freedom, then I would say Republicans are more likely to be more polarized. And so it kind of depends on what type of religious freedom questions we're talking about.
So one more question before we move on.
I'm getting all the questions here.
Well, we'll come back to you, and each of the others will get their fair share. You also talked about ways to combat that polarization, and I'll come back a little bit later after I've talked to the others about the best interventions. But I want to move a little bit in that direction by asking this follow-up. In light of the things that you've just been saying about what's the source of polarization, whether there's outliers or so on, how does that play a role in trying to combat polarization?
Yeah, I mean, I would say, so Asma and I, I've been grateful to get to work with her and try to think through bridge building. And we did a lot of like religious bridge building. So thinking about Muslims and Christians and how you can increase that dialogue and also increase like the support for the political rights of these groups. And as I go through the data and you have a little distance, I would say like increasingly, I think we need to think more about how you think about partisanship in that analysis, right? That we need to do more about the partisan interventions and not just the religious interventions. Because increasingly we're seeing these political rights and court views all really interpreted through these partisan lenses. And so if anyone wants to fund us to do those kind of work, we can talk afterwards. But no, I think increasingly we should think about how do you combat some partisan interventions and not just religious ones, because those are they're quite salient in how people are making determinations.
Thank you. Professor Struther, I really appreciated the images that you provided about showing the lack of any relationship between public views about civil rights and the First Amendment and how the Supreme Court has ruled. You focused on civil rights and the First Amendment. Is it unique to this area, or is the Supreme Court, based on any research that you've done, more responsive, less responsive in other fields of law?
This is a great question. So most of that literature that I briefly mentioned has been looking at sort of across all areas simultaneously, right? Looking like a very, very broad view. So like among all of the cases, the court decides, do we see this sort of thing? So there is evidence in prior studies that for some relationship, broadly speaking. In my own work, I have never been able to find evidence to that effect. So the preface is to acknowledge that I'm in the minority here among political scientists. Many folks do still believe that this relationship sort of obtains on average. I have a book under review that argues that there is no evidence for this sort of in general, and I've looked civil liberties and the First Amendment were new areas for me that I dug into for the symposium. But in other work, I've looked in economic cases and like criminal procedure cases and judicial power cases and federalism cases. So I have not only not found any evidence of relationship sort of across the board, but in any specific area that I've delved into, I've not found any evidence that the court sort of tracks the public.
Well, let's talk about it from a historical standpoint. We think of politics, we tend to think of what's happening right now. We're very presentist kinds of people. Historically, has the court been, is there any evidence it's been more responsive in some eras than it is today?
Yeah, so this is also a really important question because I think sometimes the Roberts Court gets framed as like sort of being like uniquely out of step with the public. Relating my answer here to the prior question in my response, I actually think that some of the reason that early works in this literature had found some response is that the public was really, really liberal on a lot of issues during the Warren Court era. So you had a quite liberal court and a pretty liberal public at the same time. I think those were essentially, that was essentially coincidental. But in our statistical models, it makes it look like there's a relationship, and the court decided lots of cases back then. So the Warren Court sort of swamps the Roberts Court when you just dump everything into one model. But when I've looked at this historically, I don't find any evidence that the Warren Court was actually responsive to the public, or that the Berger Court was responsive to the public, or something like that. So which is to say, like, no, I don't think there's anything unique about today. I don't think the court has actually ever been responsive, and that our sort of the discipline's view that it has been just like statistical accidents, and coincidental, not any sort of like meaningful relationship between the public's views and the court's decisions.
Let me turn to soon-to-be Professor Udine. Welcome to the Legal Academy. Some might worry that your focus on social science and judicial rhetoric would prioritize emotional appeals over the rational, legal sorts of things that we would expect the court to do. So how do you respond to the concern that what you're really doing is suggesting that the court be more touchy-feely?
Mm-hmm. Yeah, and that's a common concern. Like, especially because people think back to things they've seen in opinions that feel touchy-feely to them. And they're like, is it more of that? Is this sort of just being emotional, or is it pandering to the public? I mean, we can sort of talk about how this might tie in with Logan's work. But somehow just sort of compromising the clarity of the legal ruling, making things kind of murky instead of giving us the answers, like what we expect from an opinion. And yet all the literature on this emphasizes that there's nothing about these strategies that's supposed to take away from the clarity of the legal ruling. Now, in some cases, it might require a narrow ruling, like the types of things that I talked about in the context of Masterpiece, where instead of sort of having these more sort of broad, sweeping sort of decisions, you decide to sort of rule very narrowly. And so in some cases, it might very much involve that and be tied very intricately with that. But or in other cases, in the case of a Obergefell, you can still have a broad ruling. But no matter what, you can have clarity, and it doesn't take away from that in any way. In fact, a lot of this research kind of responds to the common sort of conception that, and held by judges and the justices themselves often in many cases, is that if we just sound very definitive, if we say that we have history sort of conclusively on our side, that we have the empirical evidence on our side, if we're just really kind of black and white about things, that'll somehow foster more confidence in the decision. And in fact, what the research on cultural cognition, for example, finds is that it's quite the opposite, that people are going to look at the ruling, especially in these really highly charged cases, and they're going to filter them through the prism of their particular identity, the particular sort of sets of experiences. And the more definitive you are, the more it's going to seem like, well, this doesn't seem honest. It seems to be ignoring all these experiences that people have that would conflict with what the opinion is saying is black and white. And so if you actually create space where you acknowledge these diversity of experiences, you're actually going to engender more acceptance of the decision. And it might be counterintuitive, but that is what the research has found. And similarly, Tom Tyler's work on procedural justice has also said nothing about the fact that that a particular decision in a case or an enforcement action, a lot of his work kind of deals with law enforcement and how people respond to law enforcement. It doesn't say you have to change the result. It doesn't have to change what you're doing, but it's just the way you make people feel. Like if you make them feel like their dignity is respected, for example, if you show the fairness of the procedure, that will help people accept the decision. Again, even in cases in which they might disagree with the ultimate decision. So that's really what this paper is about. It's about kind of moving beyond our ideas of what sentimentality or sort of touchy-feelingness looks like, and kind of saying this is actually rooted in something very precise that the social science research has identified for us.
Thank you. So I want to come back to Professor Lewis and talk about combating polarization. We all assume that polarization is a bad thing.
Yeah.
And how should we combat that based on your research and your experiences, and what techniques, what interventions seem to work the best?
Yeah, I mean, I think there's two things. One is trusted sources, right? So people getting messages about reduction of polarization or supporting people who maybe they're less likely to support. But getting those through trusted sources is key. Now, who's a trusted source is one of the tricks, but some of the things that we have used are people's religious clergy people. So and the closer they are to their to them, so the better, right? So not just like national leaders that they might feel like they're different from. So trusted sources is a part of that. So in group. Sources that can actually extend to outgroups seems to work. The other thing that is also, and I think this speaks in somewhat to Asma's work, is like acknowledging the groups that they have concerns, right, and that they have preferences, or that they have they're feeling vulnerable in some ways, but then also extending saying like, yeah, other people are feeling vulnerable too. I think this sort of in-group solidarity to extend a sort of out-group support for rights and liberties is a big part of that. Asma and I actually did some focus groups. We went to some Christian. We met with some Christians, especially conservative Christians, and talked about these things. And in many ways, it's these stories about having solidarity with the groups that you're talking to, but then also talking about your own personal narrative. I think that was really powerful, and especially when Asma would explain some of the work that she had done about Muslims and being denied rights and being denied religious freedom. When she began those conversations with them in a way that I think toned down any skepticism and let them know like she cared about their rights too, and then told her story, that seemed to work well in the focus groups when we sort of varied the approaches. And we find some similar uptake in the statistical models. When you randomize those types of messages, they seem to get a little bit more support than others, including support on makes people feel more warmly to minority religious groups, Muslims in particular. It makes them more supportive of those religious freedom claims that come from minority groups. And so those things I think can be useful.
Last question for you for the moment. We have a new presidential administration that's been in place for about 60 days. The political environment is changing or continuing. How do those changes, the present environment, affect the sorts of things you're talking about? How kind of looking forward and trying to predict where we may be going?
Yeah, so there's a little bit of vibes in this one, but part of in the last Trump administration, I think you saw heavy emphasis on religious freedom, religious liberty. You had religious liberty task force. It was a key part of some major speeches and major elements of the administration. This administration, I think, that has not been front and center. It has not been a core piece of, I think, the policy agenda. I think it represents a shifting approach to how to the political world and what the political realities are. And so I do wonder about sort of the importance of religious liberty conversations and where that's going in the next few years. And so I think we should all be sort of be thoughtful of that, right? Thoughtful of the differences between the two administrations and how they I think in some ways the silence about religious liberty should matter for those of us who care about this issue, because what is that telling us? And so we're early on in figuring that out, but it's something that's piqued my interest over the last few months, and I would encourage all of us to think about where we think this is going.
Professor Strother, in light of what you have shown us about the Supreme Court not being particularly responsive to public opinion, does that affect the court's legitimacy?
So here I'm going to draw on the sort of the other side of my work, the stuff that I didn't present today. But the short answer is yes. The court's legitimacy is founded in important part on essentially like short-run decision agreement. Normal people, right? I'm not here necessarily talking about lawyers, but overwhelmingly normal people decide what they think about the court based on whether they like what it's doing. Most people know essentially nothing about courts and how they work, certainly nothing about the Supreme Court. So they see a policy outcome and they think, do I like that? And if they like it, then they say, well, that means the court was doing the law, so it's doing a good job. Good job, court. I like the court. They don't like it. They say, oh, the court was doing politics. And so I don't like the court. The court shouldn't be political, right? So people say the court is political when they disagree with the outcomes. They say it's legal doing law when they agree with its outcomes. So I think the stuff that I showed you today gives us a sense of why the court, like, I don't think can really move the needle in a meaningful way on like depolarizing us. So one reason is like people aren't gonna, So if the court does stuff, if the court is way out of step, as many people assert today, then like lots of people are gonna be unhappy with it. They're gonna say the court is doing politics, and they are going to then say, the court maybe shouldn't be doing all this stuff that it's doing, right? Like, so the court's legitimacy in the public's eye will suffer. But precisely because of intense polarization on a lot of high salience issues, like the ones we're talking about today, there is no decision the court can make that won't make a lot of people mad, right? So on a closely divided issue, a large portion of the public is going to say the court is doing politics no matter what outcome it reaches in the courts, right? So this is why I don't think that the court can actually move the needle too much given polarization.
Follow up on that. Wouldn't we not want the Supreme Court to be responsive to public opinion? It's supposed to be independent, not just swayed by politics, making decisions based on legal texts and legal traditions. Isn't it a good thing that the Supreme Court then is not responsive to public opinion?
Yeah, it certainly might be. It's not obvious to me that we want a court that is responsive to the public, is taking the public's temperature on issues. On the other hand, Anthony Kennedy said shortly before his retirement that any nation that relies on 9 unelected judges to resolve the most important political questions of the day is not a functioning democracy. I largely agree with this sentiment. And I think since 1925, the Supreme Court has behaved like ever less as a court. So insofar as the court is doing policy in a lot of its decision making, then maybe thinking about the court as a neutral arbiter of the law is not the most useful sort of approach. But if you think the court's a court, then yeah, probably non-response is good.
Right. We'll get used to being called Professor Udine. I'll ask the next question of you. Some might say that using inclusive and conciliatory language for those who have lost can come across as condescending. How do you respond to that? Is there some approach that can be taken here to make that attempt in rhetoric feel less condescending to those who are going to be unhappy that they lost the case?
Yeah, and that's, I think, a natural feeling because it kind of seems like you're just sort of giving the losers some scraps, right? And people think about this. They have specific opinions that they reference where they think what I'm proposing is in action, and they think about their feelings, and they're like, I actually responded to the opinion in a really negative way, and I did find it very condescending. But at the same time, it's like there's this sort of like default way of thinking about this type of language as something as a negative, as something that's sort of insincere or unclear. But then simultaneous to that, there's also, for example, in the legal literature, a lot of acceptance of the scholarship around procedural justice. And there's something sort of really intuitive about that. That, yeah, like if you make people feel that they're respected and sort of foster the sense of like trustworthiness, then people are going to respond differently. And then they are going to be more open to whatever the ultimate ruling is. And so I'm trying to reconcile those two things, that there's something intuitive about one thing, but also so intuitively positive about one thing and negative about the other thing. And like, how do you bring these two together? And it really kind of goes back to, there's something about sort of like the precise tools and how you incorporate them. And so in my most recent paper, I actually have sections of the paper where I offer sample rhetoric. I take the reader through 3 different cases: Roman Catholic Diocese, Kennedy v. Bremerton, and 303 Creative. And I actually offer sort of a rewritten version of the opinion, or at least portions of the opinion. And people's reaction time and again to that sort of sample rhetoric is that, and the sample rhetoric incorporates all of the sort of specific strategies that I lay out in the paper, is that, oh, I actually really like that. That was really helpful. I wish the court would write like that. Right. So at the same time, there's sort of this gut reaction that we don't like what we're seeing in these other opinions, but then also at the same time, a generally sort of positive response when these particular strategies are employed very carefully and specifically in opinion writing. And in a way, I kind of think about this in terms of sort of like how would we think about sort of like the minimum levels of like what's required, right? Is it just sort of shallow engagement, or is there something sort of deeper and more thoughtful and more authentic and more honest about the way the court engages in this sort of process of acknowledging diverse identities and vulnerabilities? Like, I think people can sniff out what's authentic versus what's sort of just there to kind of make it seem like the court cares, but the court doesn't actually care. And it's really kind of about just achieving that sense of authenticity, which can sometimes just be a question of like, how deep do you go? Like how much do you actually try to grapple with what the other side might be thinking and feeling, and then use these strategies to sort of incorporate that acknowledgement of those experiences into the opinion.
25 minutes ago, it felt like a really good idea to come and stand at the podium. And then I remembered I'm an old white-haired man with artificial knees, and the worst thing to do is stand in place. So I'm going to hobble back to my chair. And I do note that we're running a little bit ahead of schedule, and we can't have, that could mean that we would finish early, and we can't have that on a Friday afternoon. So I'm going to, before we turn to the audience, I'm going to ask each of the panelists if they have a question for one of the other panelists. And I'll begin in the same order with Professor Lewis. Putting you on the spot, do you have a question for one of your co-panelists?
Well, I have lots of questions for them. No, I'm curious about how, Asma, you tested the way people have reacted to these various messages. Is it how did you go about getting people's reactions to the different approaches, or is it more of an you're taking the theories and the approaches that other social scientists have done and then applying it to the court? I'd love to know a little bit more about how you're sort of examining the types of language and maybe giving some suggestions about what could work better.
Yeah, I think that's a great question, Andy, because I was hoping you and I could figure out a way to actually test it. But so far it's been just entirely through sort of taking the paper out, paper where I sort of wrote up all of this, and lots of people are reading it and kind of just getting their feedback. And so it's sort of just through this sort of informal process that I've kind of entirely anecdotal at this point, in terms of the way that people sort of gut reaction. That's a concern about condescension is very widespread, right? Like, this language is really condescending and annoying when the court does this. But then at the same time, kind of seeing very different reactions when I sort of set out the sample language.
But I think that is the next step. Like, how do you kind of take this and test it empirically? I think is where I think one of the next sort of natural steps for my research.
We had the Braver Angels simulation earlier today, and it gave me your thing gave me a little flashback to that a little bit, right? Like you're sending certain signals and certain offering hands of support, but you're not conceding, right, that they're going to win, and so I am curious on a sort of a mass scale, so not just like what somebody says, right, but like on the public more broadly, like how they would interpret that. So okay, we'll talk about it.
Yeah, and I should note that the specifics of the framework, so my framework has many different pieces to it, but each of those pieces is rooted in actual empirical studies where people have found that if you have these two focus groups and you give them various versions of a Supreme Court opinion, one that incorporates some of these strategies, one that doesn't, that people do react differently based on that. So each individual component has been tested. It's really just a question of like what happens when you incorporate the full framework that has all of these different components.
Question, you have a question for us?
I do. So my question's for Andy. So the sort of take-home message from your presentation, from the paper you're working on for this, is that both message and messenger matter. And you talked about some of the effects you found in your studies about people feeling more warmly towards a group after treatment, things like this. So my question is how much do these things matter, right? So for like the lawyers in the room, like statistical significance means like we're pretty sure it's not zero, but that's like all it means. So what I'm asking Andy, like this is a classic like social science question of like what we call substantive significance. Like so, did the statistically significant effects you found did they like how much of a standard deviation, like how much?
These aren't they weren't enormous moves for sure, right? Like I think in the like a quarter of a category in a 5-point scale would be like was one of the move points. Does that make sense? On average, controlling for other things, and so not enormous moves. The other thing we can't test is the longevity of them. Now we had the treatments were sort of very quick, right? And so the hope would be that within some extended engagement in this kind of work that you can get both some larger effects and some more long-standing ones. But we're seeing at least some momentum, right, that these have the potential to work. But I don't think that they're not going to cure all our ills. Does that make sense? Opening up a conversation, making people a little bit more responsive is kind of the main thing we're seeing.
Thank you. So the last question before we turn to the audience, Asma Uddin.
Yeah, my question's for Logan. I saw your study as being about results, right? That the court doesn't rule a particular way in order to respond to the public. There's an effect of the public on the court and the court on the public. And so I distinguish my own work from that, in that it's not about the ruling, it's about the opinion writing. It's about how do you sort of explain the ruling in a way that's broadly resonant. But I'm curious as to like how you're thinking about the connections between your findings and what I'm proposing.
So this is a great question. So for what it's worth, from my perspective, I think we can both be right. I think we both be right in two ways. So one is I think we're largely talking about different people. I'm talking about, we'll say, normal people. I'm talking about the mass public. And I think my read of your stuff is like you're talking about people who read Supreme Court opinions, right? It's like the normal person, like even the normal like very like high political engagement person might like read the New York Times or something like that, right? Or fill in your favorite newspaper. But at most, like something like that is going to have maybe some snippets from court opinions, right? But almost no one who isn't the sort of person that would sit in a room like this, actually reads Supreme Court opinions, right? So I think the sort of thing that you find is very likely true for people who read court opinions. For people who aren't going to do that, right? So for most people, I think those outcome orientations dominate. The other way that I would say that I think there's no real no disagreement with a lot of bite between what we're talking about. It's just thinking like at what margin. So I have quite a bit of work that shows that outcome orientations dominate. Again, thinking about like me looking at the mass public. But that doesn't mean that these like rhetorical things that you're talking about also matter at the margin, right? Now, it might not convince a person that like, oh, actually, I'm okay with, with like a person who's like strongly pro-choice, like, oh, actually, I'm okay with Dobbs because the language and the opinion was conciliatory, but they might hate it a little less, right? So like in other words, so this is related to the point, the question I raised with Andy, right? So it can be true at the margin, but still not be doing like the big work of moving like sort of like the big feelings, if you will. Does that make sense?
It does make sense. And I think of it more in terms of acceptance versus agreement.
Sure.
So it's not, consistently the research is focused on, it makes people see the court as fair or as a fair sort of arbitrator, even when they oppose the ruling, right? So it's not a way of generating agreement. People aren't going to suddenly change their minds on abortion rights. And in fact, I do actually say that there's certain issues like abortion issues that might actually this might not work in just because they are so like supercharged. But regardless, the idea is that it's more about accepting the court as a fair institution, as a fair and reasonable institution, as opposed to agreeing with what the court has decided. So that's another distinction.
Gabby is standing in the back, and that makes me guess she has a microphone in her hand. She does. So I see someone up here.
Thank you. Thank you. Yeah, there we go. Thank you so much for these wonderful presentations. I have two questions. One is for Professor Strother. Is that how I say it? Yeah. The question I have is, often when I think about how people are interacting with the court and whether it's contributing to political polarization, I think in terms of individual justices, and so not so much in terms of the court as a whole, but how people respond to Roberts or Thomas or Barrett. And so I was just curious about how your research was mapping on to also the kind of lore about the sense of justices as personalities also on the landscape. So that's one question. And then, Asma, thank you so much. So Professor Uden, what struck me about your work is also the connection with the really deep literature on law and emotions, law and the humanity, Noonan's work on persons and masks of the law, the contributions of feminism, and so even as you say, what people are both thinking and feeling, and kind of a full-bodied response. And so I just wanted to suggest also that we kind of flip that what we ask law students to do in how they're analyzing cases and kind of cutting off their emotional responses is actually very strange and very strained. And so I was just curious about I was remembering a conversation about this criminal law duty to rescue case about this guy who stuffs his mistress into a basement when she's drugged on morphine and she dies, and the opinion is just awful. And I remember a conversation with the students saying, doesn't this make you angry, right? Why aren't we having a conversation about how angry we are about what happened to this woman, right? And so that sense of also like, what is the space for the emotional life and how we're thinking about how we read opinions. And so I was curious about the extent to which your own work in this area and in rhetoric is bringing some of those dimensions in from a kind of interdisciplinary perspective.
I think it was for Professor Strother first, and then for Asma.
Sure. So thanks for the question. Most of my work focuses on feelings toward the court, generally not toward individual justices. Certainly true that some justices have a sort of like celebrity status among like subsets of the public. To the extent that I have looked into this, I have a little bit of work that's looked at like the off-bench rhetoric of justices, so like giving speeches, in law schools, or giving speeches to the public, or giving public interviews and stuff like that, seeing how people react to those, we'll say, less formal interactions they might have with justices. Though still the outcomes that I was measuring are really more attitudes toward the court, not toward the individual. But to like the global finding in that part of my work has been that, the justices, when they are talking to the public, say like, oh, we're a court, we don't do politics, we neutrally consider the facts and then apply the law as the text requires or whatever. And this actually does cause people to think about the court as more like legal when they are not also being treated with information about court decisions, but when they're being treated with information about court decisions at the same time, then that outcome orientation still dominates. To the extent that I've found evidence that there are sort of like justice-specific effects, whatever effect you get from that off-bench rhetoric is sort of magnified by some sort of affinity towards or against that justice, right? So like Democrats reacted really negatively to Brett Kavanaugh treatments, for example, like that sort of thing, right? So like versus out partisanship amplified or like minimized the sort of the effect sizes. Yeah, sure. Esma?
Yes, thank you for the question. And, and also just kind of planting the seed that you see this sort of overlap with the law and feminism literature, because that wasn't something I had thought of. I mean, I've been thinking about law and literature and the overlaps with that. But that said, I mean, I do have a paper that will be coming out soon where I explore, I mean, there's a number of scholars who've kind of been thinking about what they call the resonance gap, right? So where the way that the court writes and the way that's sort of acceptable, what we consider it to be an acceptable way for it to write is, it makes sense for lots of different reasons, but it also, right, there's established modalities, but then there's established anti-modalities, things that are ways for the court to not be basing its constitutional interpretation. There's sort of certain things that are considered illegitimate. And while there might be consensus around what is the acceptable modality and what isn't, there's still the fact remains that there's this resonance gap, right, which is what they call it. And so Jamal Green has this paper on the role of pathos and like how, how can we employ pathos without necessarily creeping into the space of the anti-modalities? And so I explored this in a paper where it's like, well, how do these social strategies kind of give us some ideas, some strategies as to like how you can effectively use pathos, again, without violating sort of this norm around what's an anti-modality, to make things more sort of resonant with broader groups of people. And so the effective use of emotion, like, again, how do you use it in a very sort of specific, targeted, structured way that still fits within what we understand to be the accepted sort of modes of interpretation. So that's the extent to which I have begun to think about this. And also, I would say, again, rooting it in this in growing sort of acceptance and understanding of the fact that there's something about emotion that helps to generate the type of acceptance that is needed in times like today when things are so polarized.
Next question, please.
Thank you for the panel. This is a question for everybody, everyone on the panel. If you want to answer it, go ahead. If you don't want to answer, you can punt it. If it's stupid, just ignore it. As I was listening to the presentations, it seemed to me there was something unstated in all of them. On the one hand, you have Supreme Court decisions, and on the other hand, you have popular reactions to them. But there is no account of how these decisions flow down into the public. And so I'm curious if any of your work thinks about that and whether that makes a difference. And what's the role of civic education? Is part of the problem here that there has been a decline of civics education in a sort of a broad general sense, so that as a result, the population is much more manipulable by partisan media because they lack the kind of foundations in American civics that would be necessary for them to understand court decisions properly.
Logan may have the most work on this. So my sense is that there's a lot of shortcuts that are going on, and there's a lot of non-recognition of even what, those who are in the legal, or I'm a sort of legal-oriented political scientist, like what we would think as cases that would matter and that we're, like they're the blockbuster cases of the term, like these aren't really breaking through to most people. Because most people have, all kinds of other lives and issues and media consumption that's not taking them down this road. So Logan, I'd be interested in what you may have seen or heard. There's a lot of shortcuts, I would say. So there's a little bit of news snippets, a little bit of, I have a trusted political source and they've made this statement about this case. And so that must be what the core holding is, right? Or what the analysis is. And a lot of that is based on who it's good for. And so civic ed, I don't know. I mean, the question, do I think more people should pay more attention to the specifics? Absolutely, right? Though maybe, and part of it depends on what you think, what kind of role you think the court's playing. But Logan, do you have any insight on this from political communication and political science?
Sure. Yes, I think this is a really important question. So it actually is one that I've done some work on. So one way to think about the work that I didn't present today, but work that sort of like treats people with information, so like the survey experimental approach that like Andy described in a different context, what you're sort of simulating in this is a certain type of interaction with information with the court, right? But as I've sort of hinted at a couple of other answers, like most people know almost nothing about the court, like almost nothing about politics, generally about political institutions, generally, like public ignorance is like pretty profound. And people know less about courts than about like legislatures, right? About Congress. Partially this is because like legislators have PR arms essentially, right? And courts generally don't. So information is extraordinarily low, and that makes it pretty easy for people to be influenced, right, by like most recent information, by selective and strategic framings and that sort of thing. So the way that I think you should think about results from survey experimental work is you're recovering something like a ceiling effect, right? So like provided that everybody was treated with information, like this is the effect that you would get. Right? But because in the real world, almost no one is treated with that information, that like, the sort of real world effect of most things, unless there's super high salience, front page news in a sort of sustained way, then like there's really not going to be any effect, right? So to the extent that people do in fact get news about the court, you have to think about where do people get their news, right? Most people today don't get news, like period, like do not follow, like the information environment that exists today lets people opt out really easily. Among people who like actually opt into receiving news, varies hugely on like age cohort, like where you're getting it, right? Old people read newspapers, right, like me. But then you've like increasing prevalence of in like sort of the middle-aged cohorts of partisan TV and partisan internet sources. Among young people, like the modal like 24-year-old gets their news from TikTok. Right. So the information that people get there does not look like the stuff that we treat people with in our survey experiments. Right. So it's a sort of long and rambly answer, but it's the right question. And I don't think like as a discipline, political science, communications, et cetera, have a great handle on what are people actually being treated with on a day-to-day basis. Right, other than nothing.
We are largely out of time, but Ozma, if you want to speak for just a minute or two, we could take that.
Yeah, I mean, I've spent some time thinking about this as well. I haven't tested it experimentally, but on the one hand, I think that when you present the research like mine, where it's about what the court can do in terms of sort of mending some of these political divides through its opinion writing, the natural next question is like, well, how many people actually read these opinions, and what effect is it actually having on people? And to which I respond that I think this is a good in and of itself, regardless of, I think it's important to get it to the masses, but I think that this is something the court should engage in regardless of what those hurdles are in terms of getting it to most people. That said, I have spent some time kind of thinking about the role of cultural intermediaries. I think that especially in a lot of the cases that I explore, that language is
coming, some portions of it are making its way to broader audiences. There are sort of middlemen who are filtering it. And I think that depending on what the court says, like if in Masterpiece Cake Shop, if it's really kind of layering in all this language about the sort of dual vulnerabilities of both parties, that it's more likely to actually make it down in some sort of more nuanced form, as opposed to if the court was writing in very starkly divisive ways. There's research that says that when the court is less polarizing, then the opinion itself is less likely to be reported on, just because it doesn't fit sort of sensationalist headlines. So there's some sort of inherent worth in kind of like toning down the divisiveness, because just the fact that fewer outlets will be reporting on it can be a good in terms of helping to manage the social temperature.
I couldn't help but notice that no one asked me a question, so I guess I finished the session as it began, with me being the least. And that is exactly how it should be. We've had a wonderful panel. Let's please thank Professor Lewis, Professor Struther, and Professor Udine.
And while our speakers go and find their seats again, or if they want to stay up here while we conclude, they're more than welcome to. I just want to take a couple of moments and thank a few specific people. First and foremost, to Professor Berg and Professor Udine for helping to corral all of these phenomenal speakers and invite them to our university here. The speakers that we had today are truly top-notch, as I think came through from their remarks, and I mean, honestly, just reading their bios. And getting the quality of speakers that we got today are not possible without the quality of professors that Professor Berg and Professor Udine are. So let's give them a round of applause as a big appreciation. I also want to take a moment and thank a couple of behind-the-scenes people. Devin was already mentioned, the events manager. The way that this room is set up would not be possible without her. The way that you're hearing me through the microphone and through the PowerPoints and our Zoom presenters would not be possible without Xander in the very back. So a big thank you to him. And then Carrie as well for putting our programs together. They look great. So a big thank you to her, as well as catering. I don't know if any of those folks are still in the back yet, but a big thanks to them as well. Finally, I want to thank, or second to last, I want to thank our Law Journal members. I'm a 3L. We have multiple 3Ls in this room, and this symposium marks our last in our law school journey. And the symposium that happened today, the one that we had in the fall, then the other symposiums that we've had throughout our time in Law Journal would not be possible without all of the Law Journal members. So a big token of my appreciation as the symposium editor to all members of the Law Journal for carrying yourselves so professionally, for asking such great questions, and for helping me in putting this event on. And lastly, of course, I need to thank each and every one of our speakers. When we sat down to, or Professor Berg and Professor Udine sat down to really craft what this event looked like, and then when they brought me into it to help plan and organize it, I think one of the big things that we wanted to focus on was bringing folks with varying points of view together to have crucial conversations. And I think that today, I hope you all were able to see that we were able to accomplish that. And I really appreciate each and every one of the speakers for sharing their time, their expertise, and their opinions with us today. And so with that, I'll invite Professor Berg up to the stage for a final conclusion. Then once he's done, you all are good to go on your way. But once again, thank you very much.
I don't have anything to add to that. Thank you, everybody. If you haven't been thanked, but you should be thanked, I thank you as well. And just the last thing I'll say is that not only was this a tremendous engagement between speakers, but there's going to be a great set of papers that come out of it, and the Law Journal members will be participating in that, doing editing, and I'm just really looking forward to seeing the variety of methodologies, the variety of perspectives, the variety of issues that this takes on when you bring a bunch of really interesting, thoughtful, knowledgeable people together around a broad topic and just let them talk to each other. Really good things happen. So I think that's what happened today. Thank you, everyone. Speakers, you're welcome to come up and join the faculty for refreshments if you're able to stay. Otherwise, everybody have a safe trip wherever you're going, and thank you.